for the day before I give any opening remarks. So I'm going to share a screen uh, for what the program is about and why we have brought all of you here online. So as for the speakers and the commission, they know about this. So this, if you can, I hope you can see my screen. Great. So this is a program being organized in collaboration with the United Nations Commission on the International Trade Law. Um, our name is the African Center for Collaborative Dispute Resolution. We are based in Accra and we do training and we do also resolve disputes using mediation and arbitration across Africa. So we are happy that we were given the opportunity to host this UNCITRAL Day in Africa. So the team that UNCITRAL is using is the role of UNCITRAL in the modernization and harmonization of international trade law. But this specific event is on the UNCITRAL mediation and arbitration rules, lessons for after and for non-state actors dispute resolution, which we have scheduled for today and we have all gathered here to do. The background is that the African Continental Free Trade Area represents a landmark achievement in African regional integration agenda, aiming to create a single market for goods and services across the continent. As trade expands, dispute among non-state actors such as business, SMEs, and medium-sized organizations are inevitable, and we cannot avoid that. Effective dispute resolution mechanisms are therefore essential to ensure confidence, predictability, and fairness in cross-border trade and transactions. So UNCITRAL has developed globally recognized instruments and including the UNCITRAL arbitration rule, which started 1976, revised in 2010, 2013, and 2021 currently. And the UNCITRAL mediation rules in 2021. This text provides flexible, neutral, and widely accepted framework for resolving disputes. Their lessons and best practice can inform the design and implementation of after dispute resolution mechanism for non-state actors who require accessible and efficient process. Because when you look at the African continental free trade, it is state to state more centered. So we are looking for an opportunity where the non-state actors can have rules to dispute solution within the after. So the objective of this webinar is to raise awareness of the UNCITRAL mediation and arbitration rules among academics, policymakers, and practitioners in Africa, to explore how these rules can complement after dispute resolution framework, especially for non-state actors, and to identify opportunities for harmonization between UNCITRAL instruments and African regional trade laws. To build capacity among students, researchers, and practitioners in applying UNCITRAL text through real-life disputes. And so this is the program outline. So as we are doing the opening and introduction, we're going to introduce our speakers to you. Then we have welcome notes by the president, the founder and president of the center. Then we have an address by the UNCITRAL Secretariat, which will be represented by our able Benjamin Hassan. Benjamin, forgive me if I'm unable to pronounce your surname. You can do it better
It's
for us.
it's okay. It's all right.
Then he's the legal officer and the technical assistance coordinator at the UNCITRAL Secretariat. He will have some time to tell us more on that. Then speaker session, we are going to introduce our speakers. Then we have speaker one, who will talk about UNCITRAL framework on alternative dispute solution. An overview that will be done by Miss Judith. Miss Judith, when you also come, you do your the surname for us. I don't want to butcher it. I may call it NIPA, which may not be what it represents. She is the legal officer, working group 11, I think working group 2 on dispute solution, secretary, UNCITRAL Secretariat. She will also have 15 minutes. Then we have speaker 2. We'll look at UNCITRAL arbitration rules, applicability to after dispute involving non-state actors. We'll have Dr. Kemfan Gasson, Magistrate and Director of Legislation at the Ministry of Justice, Cameroon. You also have 15 minutes. And thank you for joining us. I've seen him online. Then we'll have Speaker 3. We'll talk about UNCITRAL mediation rules, applicability to after dispute involving non-state actors. We're going to have Ms. Elom Gold Amaka, an LLB, and legal practitioner and disputes director at the Federal Ministry of Justice, Nigeria. She also have 15 minutes to talk about that. Then from then, we're going to have a panel discussion. This is where you, as participants, you also bring your input. There will be questions here for you to bring in your inputs, a time for you to bring your input. So we're going to have a panel discussion whereby we're going to have Dr. Kevin Gaston. We're going to have Foluke Akimoladun from Nigeria. She's a fellow of SIAP. And also we're going to have Miss Elom Gold Amaka, who are going to talk to us, and I'm going to be the moderator for that section that we're going to talk about. The topic, comparative insights on UNCITRAL mediation and arbitration rules, lesson for after for non-state actors. That is the for this resolution. That is the team or the event team for today. Then from there, we're going to have a closing remarks from Benjamin, and also we'll have a closing remarks from after. Then we'll bring the discussion to a close. But at the end of this webinar, these are the outcomes that we expect to have. We expect to enhance understanding of the UNCITRAL dispute resolution instrument among African academics and practitioners. We expect to have practical insights into how UNCITRAL rules can strengthen after dispute resolution mechanism for non-state actors. We expect to increase capacity of African universities and institutions to teach and research international trade law. We also expect to have the development of a network of young scholars and practitioners engaged in UNCITRAL related work. Target audience, we were supposed to have law students, researchers, academic, lawyers, practitioners in arbitration and mediation, policymakers and government officials, representative of non-state actors engaged in after trade. So that is what we're going to do. So basically, this is the 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 focus of today's discussion and the focus area that we're going to have. So on that note, and based on this overview of what you're going to do today, let me welcome all of you for this important assignment and for you to make time out of your busy schedule to join us today. We are happy and excited that you've taken time out of your busy schedule to join us. Thank you for joining us once again. All right, so now let me open the platform. Okay. Oh, let me open the platform so that I've seen our speakers. So let me open the platform for them to do self-introduction so that we can take it from there. All right, so I'll start from Benjamin.
Good afternoon, good morning, good afternoon, everyone. My name is Benjamin Hérisset, and I am a legal officer and the technical assistance coordinator at the UNCITRAL Secretariat. It's a very great pleasure to be here today. Thanks a lot.
Thank you. Let me move on to Judith.
Yes, thank you very much, Isaac. Your presentation was just perfect, so I really have nothing more to add. My name is Judith Klieper, Secretary of Working Group 2 and also involved in Working Group 3 discussions. So I'm particularly happy to be on this panel because it's rare that I'm on a panel with our own delegates. So Gaston and Elom are those who really do the work of our text, and I'm very happy to hear what they have to say.
Okay, great. Thank you for joining us. Let's move on to Elom Good.
Okay, hi. Good morning. My name is Elom Gold Amaka. I work in Federal Ministry of Justice, the Deputy Director, the Acting Director now for International Comparative Law Department. And my main desk, one of my main desks is UNCITRAL, everything UNCITRAL. Judith, nice seeing you. I missed you in Morocco. Thank you for the opportunity to be part of this. Thank you very much.
Okay, thank you. I think your camera didn't come, so we couldn't put a face to the name. Thank you.
Can you see me now?
Not yet. I don't know whether I'm the only person facing that. Is it for everyone or?
Yeah.
Okay.
Can anyone see me?
No,
But
not.
I can give evidence to the effect that it's really her. I know the voice.
That is a good one.
Thank you so much.
One.
I don't know what's wrong with my camera anyway.
Thank you. Let me move on to Dr. Gaston, please.
Yes, hi everybody. And this is Gaston Kenfak Douachny, magistrate and currently the Director of Legislation, the Ministry of Justice in Cameroon. I'm happy to share the webinar with you. Thank you for inviting me.
Thank you so much for accepting to join us. Let me go to Foluke.
Isaac, did you call on me? I wasn't sure. My network just finished. Oh,
please
okay.
go ahead.
All right. So
maybe I couldn't
thank
sound
you.
perfectly as a Nigerian. You can do it better.
Yeah. So good morning, good afternoon, good evening to us all from wherever we may be connecting from. My name is Foluke Akimoladu. I'm the managing solicitor of Trison Law Chambers. I'm a lawyer, I'm an accountant, a mediator, and arbitrator. I'm the chairperson for the Nigeria Forum of the Africa Bar Association, and I was one-time member of the Presidential Council on the implementation of AFTA in Nigeria, and I'm very honored to be speaking on this very distinguished panel. Thank you very much.
All right, great. So thank you so much. I think I have been talking for long, so let me invite Benjamin to bring his open remarks before maybe if I have anything I can add. Please go ahead. Thank you.
Thank you, Isaac. And once again, good morning, good afternoon, everyone. And thanks especially to speakers for joining indeed. It's really appreciate that we can rely on this network of experts who are always willing to share their experience and their view on UNCITRAL text. It's a great honor to open this UNCITRAL Day event organized in partnership with the Africa Center for Collaborative Dispute Resolution. I would like to warmly thank our host, especially Isaac, for their commitment and their active engagement in advancing dispute resolution across the continent. For those who are not familiar with the work of UNCITRAL, the United Nations Commission on International Trade Law, established in 1966, is the core legal body of the United Nations system in the field of international trade law. UNCITRAL mandate is simple yet ambitious: to modernize and harmonize the rules governing international business, making cross-border trade more predictable, transparent, and efficient. UNCITRAL work spans a wide range of areas, from arbitration and mediation to insolvency law, the area where I work on, electronic commerce and public procurement, to name only a few. Those legal texts, convention, model law, legislative guides, provide states with tools to align national law with internationally recognized standards. What makes UNCITRAL particularly unique is its inclusive and consensus-based working methods. All UN member states participate in deliberations. Observers from regional organizations, academia, and the private sector contribute their expertise. And our texts are developed through working groups where technical discussions ensure practical and widely acceptable solutions. This open, transparent, and participatory process is the key to the legitimacy and the global uptake of UNCITRAL instruments. It is precisely in the spirit of inclusivity and outreach that inspired the UNCITRAL Days initiative. It's a global initiative with a continental focus. We have in Africa, we have in Arab states, we have now in Trans-Danubian East European countries, we have in Asia Pacific, and in Latin America and Caribbean. And the idea is to bring UNCITRAL closer to students, young practitioners, and the next generation of legal experts. The objective is to inform, but also to inspire engagement with the idea of legal harmonization, to demonstrate that coherent legal frameworks are fundamental enablers of economic development, investment, and cross-border cooperation. Through partnerships with institutions such as IFCCDR, we seek to create platforms where young academics and young lawyers can learn about international trade law, engage in dialogue, and contribute their perspective in shaping the future of international trade law. If you have interest in the work of UNCITRAL, I would like to mention the online courses on UNCITRAL work and UNCITRAL text, which are available on our website, and also to bring the attention of students to internship programs, and I will share in the chat the link where to find relevant information after my presentation. So today's discussion provides an excellent opportunity to reflect on the intersection between UNCITRAL work on alternative dispute resolution and the broader economic transformation underway in Africa through the African Continental Free Trade Area. As cross-border trade will increase, the need for efficient, predictable, and accessible dispute resolution mechanism will also be felt very, very needed. And this is where UNCITRAL rules on arbitration and mediation, which will be discussed today, comes into the picture, because they can offer a framework that support the development of very robust alternative dispute resolution systems aligned with international best practices. All in all, integrating such framework within states arbitration center will provide and reduce transaction costs, increase investor confidence, and provide greater legal certainty across jurisdiction. Ladies and gentlemen, this year marks also the 60th anniversary of UNCITRAL. To celebrate this occasion, we have launched a global essay competition, inviting students and young professionals to reflect on UNCITRAL legacy and, importantly, on its future. The competition encourages participants to engage critically with key questions, including the role of legal harmonization in addressing emerging challenges, the evolution of dispute resolution, and the opportunities presented by digitalization and regional integration. So I strongly encourage all eligible participants, especially those in Africa, to take part in this initiative, and I will share also the link in the chat for those interested. Let me conclude by once again expressing my sincere appreciation to the Africa Center for Collaborative Dispute Resolution for organizing today's event and for working tirelessly on disseminating alternative dispute resolution to Africa. I look forward to an excellent discussion today. Thank you very much.
Thank you so much, Benjamin. And let me say that AFCOD is happy to collaborate, and thank you for the opportunity that you gave us when we applied to host this event. So, distinguished representative of the United Nations Commission on International Trade Law, UNCITRAL, esteemed speakers, we are grateful to all of you for accepting to join us today and to celebrate this remarkable day and remembering the work that UNCITRAL have done over the years and also celebrating the 60th day of UNCITRAL. So it is both a great honor and profound privilege for me on behalf of the Center to welcome you to the observance of the UNCITRAL Day in Africa. Today marks an important occasion as we join the international community in celebrating the significant contribution of UNCITRAL to the modernization and harmonization of the international trade law. We are particularly delighted that AFCOD has been entrusted with hosting this year's event in Africa in partnership with the UNCITRAL. This reflects our shared commitment to promote trade, investment, and peace and economic development across the continent. The theme for this year's celebration, the role of UNCITRAL in the modernization and harmonization of international trade, is highly relevant to the African growing economic aspirations. As African nation deepens regional integration through initiatives such as the African Continental Free Trade, the need for efficient and predictable and internationally recognized dispute resolution mechanism has never been greater. So our event team, UNCITRAL Mediation and Arbitration Rules, Lesson for non-state actors dispute resolution, provide a timely opportunity to explore how international best practice can support the development of robust dispute resolution system capable of addressing the needs of businesses, investors, and communities, and other non-state actors across Africa. So at AFCOT, we firmly believe that effective alternative dispute solution is essential to sustainable development, social cohesion, and economic transformation. So we are therefore deeply committed to advancing education, research, professional development, and capacity building in mediation, arbitration, and negotiation, and other ADR processes throughout Africa. Through our training programs, conferences, programs, engagement, and strategic partnership, APCO continues to work towards building a new generation of competent ADR practitioners and institutions capable of meeting the evolving dispute solution needs of our continent. And that is why on Wednesday, we are also doing the Africa ADR conference to broaden the discussion on the continent. I would like to express my sincere appreciation to our distinguished speakers and panelists who have generously offered their expertise and time to enrich today's discussion. Your contributions are invaluable and will undoubtedly provide a practical insight for policymakers, practitioners, businesses, and scholars alike. To all participants, I encourage you to engage actively, share your perspective. This is an open access platform. You can put your questions and anything in the chat. And in the event you want to ask a question, please do well to raise your hand, and we are going to notice you and allow you to ask the necessary questions that you have. So take advantage of this unique platform for learning and collaboration. Once again, thank you all for joining us. We are delighted to host you and look forward to a productive and impactful celebration of the UNCITRAL Day in Africa 2026. And I wish all of us a successful event. So thank you so much. So on this note, we'll move on straight to our first speaker. We'll move on straight to our first speaker in the person of Judith. So Judith,
Yes,
if you are ready,
I'm
Judith, if you are ready, please.
I'm ready, and I'm asking you, do you see my screen? Do you see
Yes,
the slide?
it is. Yes, it is visible. Yes.
It is visible. Perfect. So thank you very much for the introduction. Thank you very much for setting the scene. And I was, oops, now we have the technical issue that.
No, you're muted, Judith, now. You need to unmute.
Instead of moving the slides, I muted myself. This is a good combination, but I seem to have a problem with my slide. Let me just stop and share again. Something is wrong here. I'm sorry, this is always, normally it only happens when I'm speaking about arbitration and tech. Now it's also happening when I have there was a problem with the, let me try to reopen the.
Sorry about that is the other side of technology that we have to deal with. So just relax and share.
It's always the same. And here is the presentation. Let's see if that works now. I tried so often that now it's stuck. So what I wanted to do is setting the scene and explaining a bit where arbitration rules, which is the main topic, of course, how they fit into the general framework. So let me see if I could try again.
So if it is possible, maybe if you can email your presentation to me, I can project it for you, if that is possible.
Yeah, let us give it last try.
Okay.
So now slideshow.
Yes, it's on now, so you can go to slideshow. Okay.
So do you see it now? I can
yes.
move it. Yes, it's working. Sorry for that. So what I wanted to do is just to show you over time how we did work on our Benjamin said simple mandate. I'm not sure I would agree with the term simple, but how we coped in the area of dispute resolution with arbitration and mediation alike. And that would allow you also to assess how our rules fit in the overarching framework. So Benjamin said already we have 60 years of UNCITRAL this year, and on the screen now you see one of the instruments that triggered the establishment of UNCITRAL, and that is the New York Convention, which is one of the main pillars in trade law, and certainly the pillar for arbitration. The second text that has been developed were the UNCITRAL arbitration rules, not in 2021, but the UNCITRAL arbitration rules that have been developed in 76 and which have been updated since then quite substantially. The main update was done in 2010. The update in 21 was to include the UNCITRAL transparency rules, which is a text related to ISDS, and we come to that later. We have developed expedited arbitration rules, which are for disputes that are simple enough to be significantly streamlined to really have a proceeding that lasts 6 months from the constitution of the arbitral tribunal and not longer. We then in 85 developed a model law, which also has been updated in 2006, and to which we propose certain amendments at the Commission session this time. We have issued some explanatory texts. So you see here the notes on organizing arbitral proceedings. They also have been updated in the sense that we added specific notes. That's like a brainstorming text. What are the issues that could come up in an arbitration? And we have, and that might be of specific interest to ISAC and to the center, the recommendations. So how arbitral institutions could use our UNCITRAL arbitration rules, which are rules done in the ad hoc context, so not for institutions, but because institutions had an interest in taking our arbitration rules on board, the Commission issued some recommendations how to treat the UNCITRAL arbitration rules that they would be fit for the institutional context. We have then worked on a convention on transparency, which relates to the rules on transparency, and that very much relates to Working Group 3. I suppose that Elom is going to talk about that because she is our delegate in Working Group 3. So the rules on transparency are making treaty-based investor-state arbitration more public. And the convention is there to make the transparency rules applicable to existing treaties. And finally, we do have developed some model clauses on specialized express dispute resolution, and the acronym of this text is SPEEDER, on purpose to remind you of the speed we intend to achieve with these model clauses. So this is for those who want to have a very highly expedited proceeding on the one hand, or where you want to have a quick solution on the spot, but be able to allow for subsequent normal arbitration, like you have in construction. You have in many countries you have this notion of adjudication. So what we try to do in these model clauses is to use that idea coming from the construction area, to use it to be able to utilize it for different areas as well. So then we did the same for the mediation framework, and to present you the framework in chronological order, you would see that we adopted a different approach. So the order of our text was quite different. We started with contractual rules. So if two parties wanted to have a conciliation and mediation, then they could agree on these rules. In that context, maybe conciliation and mediation in the UNCITRAL context is exactly the same. So the conciliation rules, that the conciliation was the term that was mainly used in 1980, and this is from when the rules have been developed. And now we switched, as the lead term, we switched to the term of mediation. The second model that we developed was the model law, the UNCITRAL model law on international commercial conciliation. This is from 2002. At that point in time, we still used the term conciliation. And in this model law, we tried to discuss enforcement of settlement agreements resulting from conciliation mediation. And we were not able to agree on one single solution because states said that enforcement is just too different in the different national contexts. So you could not harmonize something that is so specific in each country. And that's why this model law from 2002 just says settlement agreements resulting from mediation are binding and they can be enforceable according to the state's wishes. We then went to work on a convention 20 years after because states said we could not, mediation couldn't unfold its benefits because the outcome is not internationally enforceable. And this is when we turn to what you might know as the Singapore Convention, which makes settlement enforcement resulting from mediation enforceable. At the same time, when we drafted the Singapore Convention, we also updated the model law from 2002 by adding a section on enforceability. We also updated the conciliation rules. And as I said, the terms mediation, conciliation in our context are used interchangeably. I don't know why it doesn't want me to speak so long, this computer. So the mediation rules are the updated conciliation rules. And then we also have mediation explanatory text. We have the notes on mediation, which highlights all the issues that might arise in an cross-border mediation. And we do have recommendations, again, for centers to use our mediation rules in the institutional context. What I wanted to do in addition to this short presentation situating our UNCITRAL rules is to highlight the work that has been done in Working Group 3 so far and in Working Group 2. In Working Group 3, we started at a certain point in time in Working Group 2 by developing these transparency rules, which I already mentioned on the previous slide. And that was the first time we didn't formulate a text in a generic manner. Till then, all the texts we did are for all kinds of disputes, for private entities against private entities, for state against states, for investors and states. So whatever text you take, it has always been drafted in a generic manner. And these transparency standards are the first time that we drafted something specifically for ISDS. And once we finalized that work, states said we need to continue working on ISDS because transparency is not the only issue that is at stake in the context of ISDS. But there are many more issues and many more concerns that we would like to discuss in the framework of a working group. And in 2017, the Commission gave Working Group 3 a broad mandate to look at a potential reform of ISDS. Here on the slide, you see all the reform elements that have already been adopted. So those who have a little sign, the Code of Conduct, investment mediation and dispute prevention. So mediation, again, a topic we have today, and multilateral centers. These are texts that have already been adopted in principle at least. And then we have a number of reform elements that are still on the agenda. There is a permanent investment court, first instance, second instance. There are procedural rules reform and cross-cutting issues still on the agenda. And finally, there is multilateral instrument to implement the reforms on the agenda. This is the convention that will allow states to adopt the different reform elements and change existing treaties so that all the reform elements also apply to older treaties. So this is what we did in Working Group 3 and where we stand in Working Group 3 at this commission session, which starts in 2 weeks already. We have in the first week, we have the advisory center. We finalize the advisory center, hopefully in the commission, and we do have the cross-cutting issues and some of the supplementary rules to the UNCITRAL arbitration rules on the agenda. In Working Group 2, which is the second working group that deals with dispute resolution, we have also texts that are ready for adoption by the Commission. And here on the screen, you see the room in which the text will hopefully be adopted. This is where the Commission and the working group is holding its meetings. And the big photo you see there has been the photo taken when we finalized the rules on to enhance the reliance on awards and notices of arbitration in the electronic format. So this is the actual picture, and I do hope that we have the opportunity to do a new picture in 2 weeks' time. Because this is probably of interest to practitioners, arbitration, how to make sure that arbitral awards in electronic form and notices in electronic form can be relied on. And what we did is not a single solution, but rather a package of different texts. So we have a recommendation to the New York Convention, the New York Convention being the main text for enforcement. We have changes to the model law on international commercial arbitration, and we revised our explanatory materials, in particular the explanatory note that goes with the model law and also the notes on organizing arbitral proceedings. And next time we do see each other, I hope that we have new texts. Once we finalize text, we also have, of course, the question, what do we do next? And here you see some issues that are for discussion on the agenda for the Commission for Working Group 2. An additional topic might be the supplement to the UNCITRAL arbitration rules that has been prepared by Working Group 3 might be looked at by Working Group 2 to see whether we could include some of these additional provision into the UNCITRAL arbitration rules. So these would be the 4 topics that are open for discussion at the Commission session. And this was the overview I wanted to give you. Of course, if you have questions, I'm very happy to respond to those, be it now or be it later. And now I'm very happy to listen to our delegates, to Gaston and to Elon. Thank you very much.
Okay. Thank you so much. Because we won't take questions now because Gaston said he may be leaving for an activity. So we'll go straight to his presentation so that at the end of the other presentation, we can take questions from there. All right. So Dr. Gaston, please, the floor is yours. Thank you.
Thank you, Judith, and thank you, Isaac. Once again, allow me first to express my gratitude to UNCITRAL for associating me to this UNCITRAL Day Africa 2026. I have been asked to speak about the applicability of the UNCITRAL arbitration rules to ACTA dispute involving non-state actors. In this regard, I must say that the African Continental Free Trade Area, that is the AFTA, was conceived by the Assembly of Heads of State and Government of the African Union with the aim of strengthening economic relations between the member states of the African Union in order to promote the development of the African Union countries through the creation of a large integrated African market. The AFTA aims to strengthen and facilitate economic relations between the member states of the African Union. To this end, it defines a set of objectives necessary for Africa's economic development, which are to be achieved through the application of integrating principles. The ACFA agreement defines its objectives that are both general and specific. Protocols have been negotiated in line with these objectives and annexed to the ACFA agreement. The ACFA is, in fact, intended to create or duplicate in Africa an integrated market in the spirit of the World Trade Organization. The ACFA provides for a system for settling disputes between the contracting countries. Indeed, Article 20 of the ACFA agreement contains a dispute settlement clause according to which 1. A dispute settlement mechanism is established, which shall apply to the settlement of disputes between the state parties. 2. The dispute settlement mechanism shall be applied in accordance with the Protocol on Rules and Procedures for the Settlement of Disputes. 3. The Protocol on Rules and Procedure for the Settlement of Disputes establishes, inter alia, a dispute settlement body. It follows from this provision that the disputes referred to here are those which have arisen or may arise between the member states of the ACFA in relation to the application of the agreement establishing the AFTA and the protocols, annexes, and appendices thereto. The dispute in question will unquestionably result from the actions of the ACFA state, which are likely to frustrate the attainment of the general objectives which the member states of the ACFA have set themselves. In this regard, Article 3 of the ACFA agreement states that the agreement aims to A. Create a single market for goods and services facilitated by the movement of people in order to deepen the economic integration of the African continent and in line with the Pan-African vision of an integrated, prosperous, and peaceful Africa, has set out in Agenda 2063. B. Create a liberalized market for goods and services through successive rounds of negotiations. C. Contribute to the movement of capital and natural persons and facilitate investment by building on initiatives and developments in the state parties and the regional economic organizations. D. Lay the foundation for the creation of a continental customs union at a later stage. E. Promote and achieve inclusive and sustainable socio-economic development, gender, equality, and structural transformation in the state parties. F, strengthen the competitiveness of the economies of the contracting state at the continental and global levels. J, promote industrial development through diversification and the development of regional value chain, agricultural development, and food security. And lastly, H, resolve the challenges of belonging to a multitude of overlapping organizations and accelerate the processes of regional and continental integration. In order to achieve the general objective listed above, the AFTA states are committed to 1, progressively eliminate tariff and non-tariff barriers to trade in goods. 2, progressively liberalize trade in services. 3, cooperate on investment, intellectual property rights, and competition policy. 4, cooperate in all areas related to trade. 5, cooperate on customs matters and the implementation of trade facilitation measures. 6, establish a dispute settlement mechanism concerning their right and obligation. And 7, establish and maintain an institutional framework for the implementation and management of the AFTA. Any act or action by an AFTA member state that frustrates any of the general and specific objectives set out above is likely to give rise to a dispute between that state and the other AFTA member states. Otherwise said, as in the World Trade Organization, a dispute arises when an AFTA state considers that another AFTA state is in breach of the AFTA agreement, protocol, annex, or appendix relating thereto. This said, in addition to the dispute between the state parties regarding compliance with their obligations under the AFTA agreement, the effectiveness of the AFTA will necessarily generate dispute involving non-state actors. Indeed, the effectiveness of the AFTA will result in the creation of a single liberalized intra-African market for trade in services and goods. In other words, in the context of this intra-African market, trade in services and goods between the traders that are nationals of the AFTA agreement countries will allow services of the AFTA agreement, its protocol and annexes, services and goods to move without custom duty from one country to another within the AFTA area. The elimination of custom duties and another tariff and non-tariff barriers will stimulate intra-African trade and investment and improve the mobility of capital. This inter-African trade in services and goods will undoubtedly give rise to commercial disputes, while the development of investment in the AFTA region will also lead to related disputes. First, the commercial dispute. The term commercial dispute describes any type of dispute that may exist in the context of a commercial relationship between two or more parties. It may concern the relationship between a trader and his customer, or that between a trader and his supplier. In the note prepared by the UNCITRAL Secretariat to explain the UNCITRAL model law on international commercial arbitration. It is called for a wide interpretation of the term commercial with an illustrative and open-ended list of relationships that might be described as commercial in nature, whether contractual or not. Thus, the condition for the existence of a
Okay, Dr. Augustine, can you hear me? I think he has frozen.
commercial dispute is a conflict dispute, and whose supreme Egypt, Ghana,
Hello, Dr. Augustine, can you hear us? Hello? Hello, please, you are muted if you can unmute.
Can you still hear me now?
Yes, now we can hear you. You went off. I think you went off for about 30 seconds. So if you can take the 30 seconds again.
Network problems. Can you hear me still? I had
Yes,
15
we
minutes.
can hear you.
15 minutes. And I've always spent 6 of these 15 minutes.
Yes,
I'm
yes.
controlling.
Yes. We are saying that you went off for about 30 seconds. So what you said within that 30 seconds, we couldn't hear. So if you can repeat that. Thank you.
Gaston, we heard that you were referring to the definition in the model law and that it was a wide
Exactly.
definition. And this is where you went off.
Thank
exactly.
you.
So let me move on and by saying that a commercial dispute may arise in a number of situations. For example, an Ivorian trader may place an order for goods recognized as eligible by the ACFA and whose supplier is located in South Africa, Egypt, Ghana, Morocco, or Nigeria. This supplier may deliver goods that do not comply with the contractual specifications or may deliver to a trader other than the one who ordered the goods or may not even deliver at all on the pretext that the Ivorian trader has not paid for the order. In practice, there is a commercial contract between the Ivorian trader and his South African, Egyptian, Ghanaian, Nigerian, or Moroccan supplier, and the parties must probably have included a dispute settlement clause. This clause refers dispute relating to the aforementioned commercial contract to the courts, mediation, conciliation, or arbitration. This type of dispute and the way in which they are resolved or supposed to be resolved are not provided for in the current AFTA framework, yet they are real and must necessarily be taken into account as they arise in the context of the large and single African market, which is the goal of the AFA. Yes, this dispute, to my opinion, which will be one of the consequences of the effectiveness of the AFA agreement, must also be taken into account by the AFA Secretariat. And failure to take these types of dispute into consideration creates a legal vacuum which must be filled by the AFA Secretariat. That should either provoke the amendment of the ACFA agreement to create an arbitration center or court for this purpose, or by expressly indicating in a text that these disputes are likely to be settled by arbitration according to the agreement of the parties to this effect. Regardless of the option chosen, the UNCITRAL rules of arbitration are eligible to be applied, to my opinion. Indeed, in the case where the option is to amend the current ACFA legal framework in order to create an arbitration core or center for the settlement by arbitration of the dispute involving non-state actors, it's possible to precise that arbitration referred to the ACFA Arbitration Court will take place according to the UNCITRAL rules of arbitration. And this scenario is not unusual if you have in mind that the Permanent Court of Arbitration applies the UNCITRAL rules of arbitration with the parties' agreement. In fact, even though the Permanent Court of Arbitration has its own procedural rule, it is very common for the parties here to agree to submit their dispute to arbitration using the UNCITRAL arbitration rules. In the case the ACFA Secretariat decides to create an arbitration court for the settlement of disputes concerning the non-state actors, it could be decided that this dispute, that the parties will apply the UNCITRAL arbitration rules in force at the commencement of the arbitral proceedings. In the case where ACFA contracting parties rather decide not to create an arbitral court for the settlement of such dispute, the parties may also decide to apply the UNCITRAL rules of arbitration to the settlement of the said dispute, particularly in ad hoc arbitration, provided the said parties have so agreed in their arbitration agreement. If the parties rather opt for institutional arbitration because they want the said dispute to be settled by one of the arbitration centers operating within the arbitration rules are applicable. The explanations to arbitration central instruments relating to arbitration. Now, what about investment dispute? And this is the second part of my statement. Litigations relating to investment. The ACFA to establish a sustainable framework to encourage intra-African investment. The investment in question here is that made in the ACFA state by an investor who is a national of another member and investment, and I quote, has an enterprise or company which is established, acquired, or expanded in conformity with the laws and regulations of the host state by an investor. The protocol on investment defines the investor has, and I quote again, a natural person who is a national of a state party in accordance with its laws and regulation, who has made an investment in the territory of another state party. B, a legal or juridical person in accordance with the definition of the legal or juridical person of the home state in this article that has made an investment in the territory of the host state, end of quotation. Even though This protocol emphasizes amicable resolutions for the investment dispute, such as consultation, negotiations, conciliation, and mediation. So shifting away from automatic direct international arbitration. This, to me, never means that arbitration might not be used here for the settlement of investment disputes. And in this regard, what was said concerning the applicability of the UNCITRAL arbitration rules to commercial dispute is to be also said here. While the protocol on investments is dedicated to investment made in an alpha country by an investor who is the national of another alpha country, nothing prevents the recourse to the UNCITRAL arbitration rules for the settlement by arbitration of the alpha investment dispute. We must have in mind that as the UNCITRAL model law on arbitration, all the UNCITRAL instruments relating to arbitration are acceptable to state in all regions and suited to the various legal and economic systems around the world. I thank you for your kind attention.
Thank you. Thank you so much for that presentation. Very insightful. We thank you so much. Now, we'll take questions for him so that in the event that he leaves, we can have his questions answered. So please, any question for Dr. Gasset so that he can answer them before he leaves. So please, you can put your questions in the comment section, or you can put your question, or you put your answer, we will be called upon to do so. Any question for the presentation he made? Any question? If you can put your hands up, or you can put your question in the comment section. Okay, the comment section, what I see is the international dispute resolution mechanism rapidly digitize how effectively to do more than up to okay. Okay, there. Framework and the entire and entities like AFTA safeguard the interests of global investor in the future of cross-border commercial. Will local market dynamics or investor legal standard play the decisive role? So I think, Dr. Gasson, there is one question in the comment section for you. So I'm reading it again. It says that as international dispute resolution mechanism rapidly digitize or through digitization, how effectively do modern arbitration framework developed under entities like AFCOD safeguard the interests of global investor in the future of cross-border commercial dispute resolution? And will local market dynamics also universal legal framework play decisive? I think this one is to AFCOD, so I think it's not directly related to the presentation that you made. Right. So please, is there any question that relates to the presentation that he made? Okay. Madam Inkubri, please, your hand is up. Go ahead with your question. You can unmute and go ahead. Please, you mention your name and your country, then you come with your question. Please go ahead.
Yes, sir. Thanks so much. My name is Obunyoung Bubre. I'm joining from Uyo, Nigeria. And so thanks so much for your very interesting presentation. You said that in your presentation, you said that AFCO provides a system for settling dispute between the contracting countries. I didn't really get. Please, I want you to throw more light into that. That's one. Then secondly, I also want you to throw light into how APCO handles investment disputes. Can you please throw more light into that? Thank you, sir.
Okay, I think let me shape the question well for Doc. It is not AFCON. He was talking about after. So he was talking
That
about
was a good
yes,
question. Yeah, it's
yes,
after. Sorry, after, not
yes. So
APCO.
it was
That was
yes.
a
So it's
super.
after. He was talking about after state to state
Yeah.
dispute resolution body that has been established under Article 20. Then you also want to find out the how after resolve investor state disputes. I hope that is
Yes.
clear. Okay, Dr. Gassin, please, your question.
Investment dispute, right?
Yes, yes,
Yes.
that is
Yes.
the second question. Then the first question is that you made mention of state to state dispute, and after she wants you to throw more light on that.
Yes, for now, I can't get you. Should I give an answer now for the first question?
Yes, please do.
So to say it very simply, I just have is to create a large integrated African market, and the settlement of dispute currently available is only dispute between the ACFA contracting state concerning the implementation of this treaty. This is what I can say. I don't know whether I'm clear enough for our friend with this answer. If she is still around, please, can she tell us whether she got something from my answer?
Okay,
Yeah.
Mrs. Igube, yes.
Yes. Yes, sir.
Is it clear enough for you?
Yeah, it's okay. It's okay. Then the second question.
Thank you. Now, coming to the second question, the investment dispute within the ACFA framework. So it is very important to know that investment in about which we are speaking now is an investment made by an investor who is a national of an ACFA country in another ACFA country. This is investment within the ACFA space by investors who are national from one or other ACFA country. This is very important to be understood. So it's the investment in we are mentioning here is very specific. The investor should be from an ACFA country, and the investment should be made in the host state should be an ACFA contracting state. This is the specificity of investment within the ACFA context. And the settlement of agreement or of dispute relating to such investment is the principle is that the parties must, as far as possible, try to amicably settle this dispute, this investment dispute. But to my opinion, this does not prevent the party in case they can't settle this, they can't amicably settle this dispute to do it through arbitration. And that is where I'm saying that even in this case, UNCITRAL instrument related to arbitration could be applied even here. Am I clear enough concerning this second question also?
Yes, sir. Thank you.
Thank you.
All right, sir. Thank you so much. Please, any
that,
further question?
Another
I'm asking.
question.
Yes, I've seen another hand up. Ngozi Miriam, please go ahead. Madam Ngozi, please unmute and ask your question.
Apologies, I was already talking, not knowing that I was muted. Good afternoon from my end, Lagos, Nigeria. Thank you so much, Mr. Gatson. Thank you to every other speaker that has spoken. Very insightful and impactful delivery so far. I missed out a point when Mr. Gatson was answering the question by my sister Joy, Mrs. Joy. So I want to know, he already answered what I had in mind, that first of all, the investor and the investment must be after national and of course after country. So where either maybe the investor is not an after national, does UNCITRAL now apply? UNCITRAL rather apply? I want to be cleared on that.
Yes. No,
okay.
no. Even though it depends on the agreement of the parties. If they agree that arbitration is the accurate way, according to them, to solve this investment dispute, is up to them to choose UNCITRAL arbitration rules to be applied in this arbitration case. This is my answer to this question. Are you around?
Yes, thank you very much. That answers my question. Thank you. Okay. I really appreciate it.
Okay, thank you so much.
Okay.
Okay, so any other question? If there are no other question, we'll say a big thank you to Dr. Gatson.
So Isaac, can you rate me? You know my commitment. I'm very sorry.
Yes. It's understandable.
May I leave now?
Yes, please, you can. Judith have opted to.
And thank you so much. And sorry, I apologize to my colleagues, and I am very thankful for the understanding.
Before you go, maybe the speakers can put on their video, then we'll take a picture with all of you, with you as well. Then before you go, I think Benjamin, that is right. What do you think? Okay, great.
Benjamin, please understand me.
Thank you, Gaston.
Sorry for leaving, but you know my previous commitment. But at the same time, I had to be here. Thank you so much.
Okay, the participants, those who are able, please put on your camera. We'll take a picture. Okay.
So thank you, and see you next time. Bye.
Goodbye, sir. Thanks so much.
Thank you so much, sir.
Thank you so much. So, bye-bye from here. Now we move on straight to.
Thank you. Bye.
Thank you, bye. Move on to Mrs. Elom Gold for her presentation. I hope you can hear us. Thank you for also accepting to do this out of your video schedule.
Yes, I can hear you clearly. I don't know whether my video has decided to cooperate.
So we can't see you. Your video is saying that it will not allow us to see you. I don't know.
Why?
Maybe your laptop. Put your hand on where the video is. Maybe there is a button there. Push it.
Nothing. This is the first time I'm having this issue. I don't know.
So there may be small button blocking the video. It has happened to me before, so maybe you can check.
I don't know. I've tried to check. I don't know what the problem is. This is the first time I'm having this issue.
Okay. All right.
So those that have seen me before can just imagine my face, like Judith and Benjamin.
Benjamin, yes.
I'm so
Okay,
sorry. I don't know why. I don't know why. Maybe because I've not used the laptop for quite some time. I've been under the weather.
so sorry.
So I don't know. I'm just opening the laptop today after like 3 weeks now. So
Oh,
so maybe that's why I didn't notice that something was wrong with the camera. All right. So thank you very much. Can you hear me?
yes, you are audible. Please go ahead.
All right. Thank you very much for inviting me. It's an honor to be on this session celebrating the 60th anniversary of UNCITRAL. And thank you to Dr. Garson. He did a great job to try as much as possible to separate the arbitration from the mediation issues. I could feel his struggle not to delve into the mediation aspect. So, but he has actually touched on a lot of things. And like has been said many times, the AFCTA, is a major milestone in Africa's economic integration and creating opportunities. That's basically what it is for increased intra-African trade and investment. And we know that as trade expands, disputes involving businesses, SMEs, investors, and of course, other non-state actors will always arise. And it's important for us to have efficient dispute resolution. And it's very good that we're having this as a means of awareness creation of how to resolve disputes, especially between non-state actors, SMEs, is very, very important. I think it will help some other countries. For Nigeria, we know we've gone a little bit far in adaptation to UNCITRAL rules, various rules of UNCITRAL. But UNCITRAL mediation rules, like we know, provides a globally recognized framework. Judith has given a whole overview of the plethora of rules that UNCITRAL has worked towards producing for international trade guidance. And it can still support AFCFTA objectives because it offers accessible and effective dispute resolution options. I would touch a bit on the question of one of the participants that she asked about ISDS, how it can be resolved for dispute issues. And basically, it's a little bit difficult on the way that the DSB for AFCFTA is formed. But we also need to know, just to put that on one side, that for investment, you have the protocol under AFCFTA for investment. And like we have that protocol, we have the dispute protocol for investment. And then we have the general dispute settlement mechanism for the whole AFCFTA. So we need to be very clear on that. So you have the provision of investment settlement for investment on its own, then you have the general. But here we are talking about, I believe, the general dispute settlement mechanism. And one of the preambles in the prevention of dispute and in settlement, one of the preambles says that it is determined to establish a comprehensive, transparent, and predictable continental legal and institutional framework for the prevention, management, and resolution of investment disputes, taking into account both the interests of state parties and investors. That's one of the preambles that makes up the DSB. So having said all that, we already know that businesses require mechanisms that are fast, cost-effective, that are neutral, confidential, and business-friendly. So mediation offers advantage over all the traditional litigation that we know and arbitration. And for AFCTA, under the dispute settlement, there is a provision for consultation. There is provision for mediation, but it did not state which particular rules. There is no prescription of which rules. It is clear on the issue of arbitration. We already know that it's the form of the dispute settlement is like the WTO. That was the format that was used. But in the aspect of consultation and mediation, it's open. It did not state that you must follow this particular pattern or you must follow these particular rules. And then we know that there are key features in the mediation rules, which Judy has given us some overview. You have party autonomy, neutrality, you have confidentiality, flexibility, efficiency. So all these things are important. And of course, it's also very relevant to AFCTA non-state actors, especially the SMEs. The making use of the UNCITRAL rules is actually something that we can look at. If you remember that I say that we have provision for mediation, you are encouraged, member states are encouraged that before you get to the point of arbitration, you'd have done consultation, you'd have done mediation before you move towards arbitration. So, and there are different ways that this can be done. Being that the Austrian mediation rules are very suitable for settling disputes between SMEs, like I say, manufacturers, exporters and importers, service providers, investors, technology and digital trade businesses. They also provide accessible mechanism for resolving cross-border commercial disputes while preserving business relationships. I think there was a question like that in the chat about cross-border. So it's also, when we make use of the Austrian mediation rules as a rule for mediation under the AFCFTA, it can also help to resolve cross-border commercial disputes. So for AFCFTA, I believe there are lessons we could learn from these UNCITRAL mediation rules and the reasons why it's important for it to be encouraged among state parties, being that there are no particular rules mentioned in the AFCFTA. We have to have that behind our mind. We are not saying use UNCITRAL rules to replace anything existing. There is nothing so far existing in the AFCFTA. We have for arbitration, but for the mediation, there's nothing specific existing inside it. So it's important for us as African states to align our mediation frameworks with internationally accepted standards, which we all know is the UNCITRAL mediation rules, and that's the mediation rules. But for us to do this, that's why this engagement is very important. The training is needed. We need training for mediators, lawyers, judges, trade practitioners, and that's basically also why it ties into the working group 3 work under the UNCITRAL, while we are moving for the advisory center, while we are asking for the standard MEC. All these things is also to build capacities, especially for developing countries and for LDCs. And because when we do that, it's easy for us to, we are not going to recreate the wheel with the AFCFTA. So even as you're creating, and as you have created AFCFTA, we have to work as much as possible to align it with existing international accepted rules and formats that have worked. So we already know that there are challenges to this, which is why one of the reasons for this engagement, there's limited awareness of mediation. Most countries, we just want arbitration. And that's why in Working Group 2, one of the things that have been fighting against a lot of fight going on has been the third-party funding. Because if you're a third-party funder, you're interested in arbitration, because you get to be paid a lot of money. So one of the challenges is the limited awareness of mediation.
solve the dispute, maintain the relationship. Most times in arbitration or litigation, you solve the dispute, you lose the relationship. So there's also inconsistent legal frameworks, which is why we're encouraging the alignment, between state parties. When you go into business with each other, look at international frameworks existing like the UNCITRAL mediation rules, which is what we are basing our discussion on. Look at it and see how to align it. Like we said earlier, training, capacity gaps. The world is moving on and no country is waiting for the other. So the gaps need to close up because we are all negotiating on same table. If the capacity is lacking, it's difficult to negotiate with equal information and understanding. So, and for us to succeed in doing this under the AFCFTA, it's important that there is mediation-friendly laws. It's to be promoted. Like I said, I encourage the use of UNCITRAL mediation rules in cross-border trade agreements. I've said it, strengthen institutions. That's for us as a country, that's what has been done here. Strengthen institutions, create legislations, review legislations to align with international accepted rules, increase awareness among business and SMEs. The FCATA Coordination Office is doing a wonderful work in Nigeria. Doing that, awareness is being created across the 36 states for us. And that's what we're encouraging for other countries also, because it makes it easier. And the goal of the AFCFTA is easily achieved. And of course, cooperation. Cooperation is important. So if we want to, bearing in mind that the AFCFTA does not provide a specific mediation rules to use, the way to go about this, if you have an SME, that's a company from another country, 2 member states with different companies, if you're entering into your commercial contracts based on the AFCFTA, you're now doing your commercial contract between each other, you can impute that. You can actually put it into your commercial contract. You can feature the UNCITRAL mediation rules into your commercial contracts. Another thing is for state parties, when the dispute arises, as you're trying to work on how to settle your dispute and the breakdown of the rules that will guide the arbitration, you can choose to adopt the UNCITRAL rules by reference. So these are basically ways that we can make the UNCITRAL arbitration rules to work very well. So for applicability, I hope I'm not rushing too much. I know I talk fast.
No, please go ahead.
Okay, that's fine. So, like I've said, if there's a dispute between Nigerian company and foreign company under the FCFTA, the UNCITRAL mediation rules can apply if it's included in the commercial contracts. And this is a decision between the parties. And of course, between Nigeria or another country and like any other of the member states among them, if both parties agree, like I said earlier, they can reference it. But no particular company can just on its own decide to apply it. There must be consensus. After all, UNCITRAL is all about consensus. So making use of their rules should also be by that measure between parties. So we would encourage, we have so many examples for us as a country where domestic mechanisms have been created to make use of this. We already have agencies where if it is another company in a member state of AFCT that has an issue, we already have rules and guidelines on how you could bring forth your complaint and the pattern it will follow. Being that we have really domesticated a lot of UNCITRAL rules and have added it to amended legislations, this has been of great help. And like I said, it's important for us to encourage regional arbitration centers. Recently, there's been a commercial contract been going on, and we had the discussion on a regional center in case of any issues. And of course, I think Kenya was chosen because I know they're called to tell me. So encouragement of making of regional centers will also help. But mediation is a very good idea for me as a person, as a lawyer. I would always push for that everywhere I go, and that's why I was really a champion for Singapore Convention on Mediation. It's a ratification for us as a country. It was really important for us to have done that. It also helped when the Arbitration Act had to be reviewed. It's guided how it was reviewed to align recognition of these awards. So, to conclude, I'll say the success of FCFTA depends, of course, not only on trade liberalization, but on effective dispute resolution. And that's why so much work is being done on the DSB. We believe that mediation rules of the UNCITRAL provides a flexible, neutral, and internationally recognized framework capable of meeting the needs of non-state actors across Africa. We know that the transparency rules of UNCITRAL encourages full disclosure for treaty-based ISDS and confidentiality for commercial disputes. So there is also the availability of amicus submissions when the matter is actually between states and a particular company is involved or SME. You can be allowed to make a submission. So it's very important if we are able to align this, and we encourage member states to consider greatly the UNCITRAL mediation rules, its transparency rules, as much as of its rules as possible that we can ratify and domesticate. It will help us to align with what is acceptable out there, obtainable out there, or implementable. Thank you very much.
Thank you so much. This is good, Elom Amaka, for your insightful presentation. Please, the floor is open for questions. Please, if you have a question, you can raise your hand. Okay. Rosalind, please go ahead.
Thank you very much, sir. I'm Dr. Manka Roslyn from Cameroon, a lawyer by profession. The question goes thus. First of all, I want to thank our sister for the wonderful presentation. She has actually given an insight of what the UNCITRAL mediation rules is all about. But then I have this worry, because when you look at the conciliation procedure and the mediation procedure, they are often used interchangeably, but there is a fine distinction between conciliation and mediation. Now, when I look at the 1980 UNCITRAL conciliation rules and the 2021 mediation rules, there is this impression that the 2021 mediation rules actually replaced the 1980 conciliation rules. So there is that nuance. I would like our sister to throw more light on this, because actually now we don't know whether the 1980 conciliation rules are still in force or the 2021 mediation rules repealed the 1980 conciliation rules. Thank you.
Okay. Thank you so much, Rosalind. I think I'll pass this question to Judith, and I'll come to Good if she wants to add anything. Judith, please, you are muted. If you can unmute.
Oh, this is not our technical day today. First, the slides go crazy, and now I forget to unmute myself. No, what I said is that this is a very good question, but in the UNCITRAL context, conciliation is mediation. So there is no difference whatsoever. This is different in different contexts. If you take, for instance, the ICSID context, they have conciliation rules, they have mediation rules, and they are really two different set of rules. The mediation rules is just the update of the conciliation rules. If you look at the model law from 2002, we said at that point in time, we said conciliation means a process whether referred to by the expression conciliation, mediation, or an expression of similar import, whereby parties request a third party or persons to assist them in their attempt to reach an amicable settlement of their dispute. And what we did is just changing the placement of the words mediation and conciliation in the definition. So now we say in the model law, mediation is a process, whether it's called mediation or conciliation. So for us in the UNCITRAL context, it's really the same. There's no difference. As to the question, which set of rules does apply? This, of course, depends on the contract. If you refer to the mediation rules explicitly, if you refer to the conciliation rules, indicating specific dates, if you say the conciliation rules at the time when the dispute occurs, then it would probably be the mediation rules. So it's a question of interpretation for those cases where you have a reference in a treaty or in a contract.
I think maybe what she wanted to find out is the previous rule still in existence, or the 2021 rule has taken effect over them? That is what she
You
wanted.
can still refer to the conciliation rules. Whatever we do, everything remains on the website. Everything remains there. And you can also, for the arbitration rules, it's the same. You can say, I would like to have my dispute solved according to the UNCITRAL arbitration rules from 1976, or the conciliation rules 1980, or the mediation rules 2021. So it depends to which set of rules you do refer in your contract. You have whole autonomy, private autonomy, to use whatever set of rules you would like to use.
Okay, maybe, I don't know, maybe she was coming from the background of where when a new law is passed, it repeals the other one, repeals and savings. Maybe that is where she may be thinking that once a new rule has come, it has repealed the existing rule. So your clarification set up the way that
UNCITRAL arbitration rules, the UNCITRAL mediation rules are contractual rules. So private party could apply them. The mediation, the model law is of course for states to take up. The convention is for states to take up, but the explanatory text, the contractual rules, can be taken up by each party.
Perfect. Okay, Rosalind, are you clear now, or do you have a follow-up question?
I think it's very clear, meaning the parties are at liberty to use either the 1980 conciliation rules or the 2021 mediation rules. That's
perfect.
That was the perfect summary.
Meaning that the 1980 conciliation rules are still in force. These rules have not been repealed.
No. Yeah. Okay. Awesome. Okay. Ngozi, your hand is up again. Please go ahead.
So thank you for giving me the permission to talk again. My question is directed to Barrister Gold Elom. I hope I got the pronunciation right.
Yeah.
Yes, okay. So first of all, I must comment in your last statement, during your closing remark, you say that the success of AFCTA is not only on trade liberalization, but also on dispute resolution mechanism. That's a takeaway for me. I like that. But I also, since you're a Nigerian, the Arbitration and Mediation Act protects the interest. You referenced the third party funder, that's the third party funding, and what it does to business relationship. Since that is protected under the Arbitration and Mediation Act of 2023, and mediation, yes, is a growing dispute resolution mechanism, very much appreciated now, but we are yet to get to that point where people, especially when it comes to commercial disputes, for people to toe the path of mediation when compared to arbitration. For family disputes, work-related disputes, yes, mediation can have a take, while arbitration might take a bow. When it comes to commercial, in most cases, investors are more tailored to go through the arbitration dispute resolution window more than mediation. So my question is, now that our law, the Arbitration and Mediation Act, protects the third party funder, and how do we now place it side by side mediation? I hope I don't even get myself confused at the end of the day. How do we now place it side by side? Because I want to get that feel that now we are all up for those of us that are mediators, certified or chartered mediators, we are now clamoring for mediation to take its rightful place. How do we now navigate the minds of people to mediation, knowing fully well that arbitration gives them that arbitral award kind of, it's more, how do I put it, very strong, and let me, for the lack of right word to use now, very strong when compared to mediation that is highly flexible. I don't know, Mr. Isaac, you can help rephrase or reframe
Okay,
I hope you got what the analysis I'm
yes,
trying to make. Yes,
yes, I get your question. I think it's all before even Amaka comes in, it all boils down to even education, jurisdiction, and then acceptability. So if you particularly the lawyers who draft the contract, you made mention of contractual issues. So the lawyers who draft the contract, what kind of clauses are they putting in the contract? What kind of dispute resolution mechanisms are they putting there? So with your question of how do we ensure that people now like or choose to use mediation, particularly in Nigeria, then I think it all boils down to some of the things that I mentioned, but I'll leave it to Amaka to add more. That is her question. So
yes,
Amaka, please.
with much reference to commercial dispute. Like I said, for
Yes.
family and work-related disputes, mediation is the go-to at the moment. Yes, thank you.
Yes, yes. So, Madam Good, please.
Thank you very much. Thank you so much for the questions. I can see many hands still up. Okay, so that's the idea of the awareness. The Arbitration and Mediation Act already recognizes the fact that we are signatory to Singapore Convention on Mediation, accepts award. There's already the background for that. So it's an issue of awareness. And for Nigeria, we already have forums and platforms, like I explained earlier. So we encourage for commercial contracts, for people like our business people that go to other countries and engage and get into agreements for supply or whatever. The encouragement now that we've been doing for the past 2-3 years now is encouraging them to inform the government. So you are aware which country we have a treaty with, which will be your protective balance, because in the bilateral investment treaty, you have the provision already of how these things can be handled, of the mediation aspect. So if you're going into commercial contracts, we encourage you that as you're getting into this, there are certain articles you have to put in your commercial contracts, which will make it that when you have a dispute, one thing that Nigeria has always pushed for is de-escalation. That has always been our anthem, de-escalation. We have never been on the part of first going to arbitration from experiences of a lot of developing countries. So there are platforms that have been created where you will make your dispute, first of all, you refer it, because dispute does not start all of a sudden. So the encouragement is when you notice there is already the forum, you have the NIPC, you have the Federal Ministry of Industry and Trade and Investment, there are departments that you submit your dispute or you send in your petition that this and this, and from there already they begin to, and that's why we have a coordination office for the AFCFTA. So if it's a member state of AFCFTA, the coordination office is already aware that something is, and tries to deal with it at that point before it gets to the point where, okay, I'm not satisfied, you don't go into arbitration. So it's for each country to make provision for these things. So the AFCFTA is not, like I said, it's not just to liberalize, but as you're opening up, you know that there will be misunderstandings, there will be clashes. So you must create a situation where these clashes can be settled, and the member states will remain member states. Thank you very much. I hope that answers your question.
Okay, I think Judy want to add up. Judy, please go ahead.
Yes, and I would like to make 2 points. The one point is we heard both Elom and Gaston in fact really talking about UNCITRAL. And why is this? Because UNCITRAL is really everyone. So we do send out for every working group session, we do send out invitations to the 193 United Nations member states. And there is a meaning that all geographical regions are properly represented in the room. There's also, we have 70 member states, and these 70 member states are from the different 5 geographical groups to make sure that every region is properly represented. But in addition, we do send out to every United Nations member state, and every discussion we are having is taking on board what everyone is saying. We try to work by consensus. In fact, till now, we only had 2 votes. One vote was on the question whether the Secretariat should move from New York to Vienna in the 70s. And the second question, the second vote was on who would become the chair of Working Group 3. So 2 procedural issues only, never on content. Meaning that whatever comes out of what UNCITRAL does is something that has been debated by everyone. Everyone who has an interest in debating the text has been able to provide the input. When it comes to mediation, we had this discussion very extensively. How could we increase the use of mediation? And that's why we developed some model provisions for inclusion into treaties that could also inspire contracts. So you can use our instrument as you want, because these are your instruments, in fact. And we also developed mediation guidelines on ISDS. And we also developed a toolkit on dispute prevention. So all of this is material that has been developed by all of us together that could help. And the beauty, so I would say the beauty of UNCITRAL is not that they are necessarily the best texts, but they are the texts that have been drafted in a very inclusive form. they're the best text in the sense that everyone was able to participate. They might not be the best text in the sense that a compromise is always a compromise. If you have around 250 people in the room, you need to compromise. And then you might have repetitions, you might have approaches that one would not take if one person is holding the pen alone. But this is the beauty of UNCITRAL, and this is where you can rely on in your future discussions within AFC FTA. And by the way, AFC FTA, the Secretariat, is always invited to our sessions. So they fuel into our discussions as well. And I think that is really the important point of UNCITRAL. It's inclusive drafting. Thank you.
Okay, thank you so much. Now let's move on to, I think the discussions are getting more interesting. So let's move on to the panel discussion where we'll ask more questions and do more discussion, right? So if you are ready, let's move on to the panel discussion. So with the panel discussion, we're going to have Miss Judith is going to step in for Dr. Gasson. Then we're going to have Follow K. Then we're going to have Mrs. Elom Gold. So please, if you are here, please Follow K. If you are here, since you are the one who have not spoken for now, I'll ask you to go ahead.
Okay.
We want your general thoughts on the team. So let me mention the topic again. We are talking about its comparative insight, UNCITRAL mediation and arbitration rule, lesson for after for non-state actors dispute solution. So that is what we are discussing. So we want to see your initial thoughts. So you have 15 minutes to bring your initial thoughts. So if you have a presentation too, you can show it up for us to see. So please, the floor is yours. Thank you.
Thank you very much, Mr. Isaac. And once again, good morning, good afternoon, and good evening to all our distinguished participants. I just want to confirm if you can see my slide, see my video, and hear me clearly.
Your slides are loading. Okay, perfect. Now we can see.
Oh, okay, great. All right. So I have 15 minutes, so I'll try and rush this through. So first and foremost, I'm going to be talking or discussing from three perspectives. One, as a lawyer, two, as an ADR practitioner, and three, as a finance expert. So I'm going to be referring to figures because sometimes I think when we look at the figures, it puts into perspective how and what we're actually, the consequences of what we're actually looking at. Now, AFTA is a continental free trade area of 1.3 billion people, also with a GDP of $3.4 trillion, which is being projected to rise to a 1.7 billion people and $6.7 trillion in GDP and businesses. So we're not just talking about a small market, we're talking about a huge market that will ultimately redefine how trade is done, not just within the African continent, but within the world at large, which is why it is extremely important that we're having these discussions at a time like this. Now, it's also important that AFTA's dispute resolution mechanism is looked at in the light of UNCITRAL's globally recognized mediation and arbitration rules. And it's very important to understand that many of the rules that countries have adopted and laws that countries have adopted in the arbitration and mediation spaces have been premised on UNCITRAL. Understandably, just like Madam Judith had mentioned, these are rules that had been discussed and worked on collectively by global voices from different states, and it has been distilled to look at what is acceptable and what is not acceptable. And because it is party driven, because it is the states that have discussed this, a lot of these rules can also be adopted on a case-by-case basis. So my focus would really be on how AFTA can learn from UNCITRAL's globally recognized rules, both on mediation and arbitration, particularly in the space of non-state actor dispute resolution. So Why does this discussion matter? We're going to have increased intra-Africa trade. We're going to see a situation where goods are manufactured in Lagos, taken down to Kenya, have a Ghanaian agent to, with respect to clearance of the goods, and is financed from Egypt. So you're going to have a lot of cross-border transactions, and with every transaction, even in human endeavor, you would have misunderstandings. These misunderstandings, if not properly managed, will crystallize into conflicts, and these conflicts would crystallize into disputes that could halt the continuation of a business transaction. So when you then get a situation where your disputes have been crystallized into a situation where the parties can no longer communicate, in order to resolve the dispute, you need legal certainty. And in addition to legal certainty, you need to be sure that whatever the resolution outcome is, whether it's a settlement agreement in mediation or an award in arbitration, there is enforceability. And this is where the big elephant in the room comes in. Article 20 of AFTA only deals with state-to-state dispute resolution mechanisms. So the question is, do states actually engage in commercial activities with each other? Maybe in very small circumstances. So in other words, a majority of the transactions that would actually that will result in the disputes that AFTA needs to be conscious and careful about are going to come up within the non-state actor spaces. So we've talked about the importance of I'm sorry. Can we still see my video, please? I have a feeling that it had gone off.
Yes.
But anyway.
No, your video is off,
okay,
but you can see your screen. Yes, your video is off. We can see your screen.
Okay, well, I'll keep talking either way. Now, AFTA is going to transform Africa's trade. We're talking about a single African market, free movement of goods and services, and regional value chains. So not just in the maritime space, we're going to be seeing that in the aviation spaces. We're also going to be seeing that in the place of road and rail. So there's going to be a completely different dynamic in terms of the logistics value chain across the continent, from north to south, from east to west. So where does UNCITRAL come in all of this? UNCITRAL's major contribution is to the international commerce that will come out of these transactions and to create certainty across diverse legal systems. So what UNCITRAL is going to be addressing is not something that UNCITRAL hasn't addressed before. When we look at the World Trade Organization and we look at the fact that AFTA was essentially designed in the same system, or like the same system with the WTO, where it is again a state-to-state mechanism. So UNCITRAL essentially was created to fill in the gap where state-to-state disputes are not addressing the issues that actually arises from trade area transactions. So it's a single African market, free movement of goods and services, we have regional value chains. How do you address the disputes that may arise? In order to understand what that, the context in which we're talking about, it's important to understand who non-state actors are. And the very first ones are your SMEs, your small and medium enterprises. The other is your corporations, and inclusive of your mega corporations, including the likes of the Dangotes of this world. Then financial institutions. And when we're talking about financial institutions, we're not just talking about banks and insurance entities. We're also talking about fintech. We're also talking about different financial or fintech finance-related platforms where payment systems are being done across the continent. And then we have digital businesses, your e-commerce. So these are your non-state actors. What happens if where someone buys a good in Botswana, pays for it on Paystack, which is a Nigerian-based fintech platform, and the goods are meant to go to Gambia. So the question is, if there's a dispute across that value chain, how is that addressed? Now, what will be the nature of the disputes we're expecting to see? We're going to be seeing them in supply agreements. You're carrying tea from Kenya to Ghana, and the clearing agent is a Nigerian. How do you address that? Payment disputes. You've paid for a good from one country from one country in Africa to another. but the payment platform is from a different African country. How do you sort out that payment dispute? Then joint ventures. Perhaps for gas, you have, hypothetically speaking, a joint venture between Nigeria and Guinea, and with respect to the supply of gas to South Africa. How do you address the disputes that may arise in that? Or maybe even the West African pipeline. If there's a dispute that comes from that, how do you address it? And then e-commerce. Now, litigation alone is insufficient. You have multiple jurisdictions. Even within my country, Nigeria, you have different manners in which these matters have been handled. The different jurisdictions within the country. You have the civil, the general civil law system. I'm sorry, the general common law system, the general commercial situations and criminal law situations, but you also have Islamic law and customary law, and that's just within one country. So how much more with other countries? So you have Egypt that has a combination of civil and Islamic law jurisdictions. You have South Africa that has a combination of different civil, common, and other jurisdictions within the country itself. So litigation cannot be the solution. In terms of delays, just having to put together your proof, your evidence, and all that from one country to the other can be quite a logistic nightmare. And then the costs of having to engage lawyers across jurisdictions, that's also going to be a problem. Then enforcement. Okay, so you have the money, you've done the litigation, you've won your case in a particular country, but the assets against which you are trying to enforce is in another country. How do you ensure enforcement in such situations, especially where those countries do not have judgment enforcement rules that is recognized in those different countries? So this is where the UNCITRAL framework comes into play. So we have Madam Judith had mentioned developments. I'll just brush through this, but emphasize the fact that the arbitration rules initially were had a set in 1976, another in 2010. In 2013, there was a transparency on public access with respect to investor state rules. And then we had in 2021, the expedited rules, which I think is very important for us to understand, because the expedited rules allows for shorter time frame for arbitration and allows for use of easier procedures that would be best suited for arbitrations that involve SMEs. And a good number of African businesses, at least as of now, fall within the SME category. Then we have the mediation rules of 2021, which has been adopted by a number of countries, including Nigeria in its arbitration and mediation rules. And then you have the model law for state adoption, which was first done in 1985 and in 2006. The Nigerian arbitration law is also designed in line of the UNCITRAL model law, and that's the Arbitration and Mediation Act of 2023. Then you have the Singapore Convention on the Settlement of Investor-State Mediation mediation rules 2018. The idea is to have mediation settlement agreements that have been agreed in one country to be enforceable in another country. So let me just quickly touch on the key pillars in the UNCITRAL arbitration rules that are important for AFTA. One is party autonomy. This is particularly significant because it means that parties, regardless of where they come from, can adopt the UNCITRAL arbitration rules to suit their particular dispute. So, like Madam Judith mentioned, UNCITRAL rules are ad hoc rules. They are not based on any institution. So there is no institutional framework per se in terms of these are the institutional rules that would apply. It is a ad hoc rule that parties can adopt to best fit their particular circumstances, which is why the UNCITRAL arbitration rules were very useful for investor-state disputes under the WTO framework. Now, here, parties may agree to resolve disputes under the rules and, of course, modify it as they deem best. Then the UNCITRAL arbitration rules, Article 11, talks about mandatory disclosures by arbitrators. So if there are issues in terms of neutrality and impartiality, those are things that the arbitrator can easily, would be mandated to make known and the parties can easily request the arbitrators to make known. Now, why this is important is because the parties can then have the liberty to choose arbitrators across the African continent and be sure that based on the rules, of course, having in their arbitration agreement the fact that the UNCITRAL arbitration rules will apply, that based on their rules, the arbitrator will have to disclose any and every circumstance that would not allow them to be independent or impartial. Then the procedural flexibility. Article 17 states that tribunals may conduct proceedings in a manner appropriate to the circumstances. So piggybacking on Article 1, in addition to the parties being able to pick their arbitrators, the tribunal also has a procedural flexibility on determining how the dispute may be resolved. So in other words, and we're talking about arbitration here, we'll talk about mediation in a minute. With specific reference to arbitration, if a matter is an e-commerce matter, parties may decide that they're going to have documents only, and everything that has to do with exchange of documents in civil litigation, we'll call that pleadings, but in exchange of documents or evidence that will be used to establish each party's position, the tribunal can conduct it in a manner that is appropriate in the circumstances. So for e-commerce, it would be strange to ask for a hearing and to ask for physical documents when the entire commercial transaction itself was essentially done on the internet. So efficiency and cost management, avoiding, so Article 17.1 talks about avoiding unnecessary display and delay and expense, which helps the parties to really razor focus on just the dispute and not spend unnecessary time on procedural excesses that may not be necessary to the resolution of the dispute. Another important pillar is the interim measures, which is under Article 26. Tribunals may grant interim measures, such as measures to preserve the particular asset in dispute. So if it's a ship, for instance, a tribunal could make a direction for the parties to go to court to have that particular vessel arrested, if that would help to ensure that the other party comes to the tribunal and puts down a security for costs with respect to the particular dispute. Now, Mr. Isaac, can you still hear me? I want to be sure that I'm not talking to myself.
We can hear you, madam.
We can hear you.
Okay, great.
Okay,
I just wanted to be. All right, thank you. All right. I'll finish up in a bit. Now, mediation as a strategic tool. So we move on to UNCITRAL mediation rules of 2021. Essentially, it is voluntary, it's confidential, it's flexible, and the aim is for it to preserve relationships. So I heard a commentator mention, I can't remember who said it, about the fact that arbitration is formal, and so they might not preserve relationships the same way you preserve with mediation. It really depends on how the arbitration is done, because you do have a med-ab situation where you start with mediation and matters that were not settled via mediation is then resolved by arbitration, or you have an ab-med where matters that started with arbitration that the parties want to agree on then conclude via mediation. So it really depends on the manner in which the parties have agreed to resolve the dispute. So, but be that as it may, mediation is very unique in the fact that the end point of the mediation process is a settlement agreement. And what that does is that it brings the parties to the discussion table, where the mediator is essentially a neutral third party facilitating settlement between the parties. And so it's voluntary. You can't force the parties to come to it, just unlike arbitration, where a party, once they are shown to have had adequate notice and the tribunal has jurisdiction and there was a functional arbitration agreement, if a party refuses to be part of the arbitration process, a default award can be given. That cannot happen with mediation. Mediation is voluntary. It's also confidential, like arbitration. It's also flexible, like under the UNCITRAL arbitration rules. And the core is for it to preserve relationships. So Just before I touch on the important aspects of UNCITRAL's mediation rules, is to also note that the International Center for Settlement of Investment Disputes, that's ICSID, under the World Bank, also has recognized the importance of mediation and also has their own mediation rules of 2022. And the International Bar Association also has rules for investor-state mediation, again, based on the fact that mediation is increasingly becoming important as far as investor-state disputes are concerned, primarily because when an investor-state dispute happens, you are trying to ensure, as the investor, you do not want to lose the investment you have already made. As a state, you do not want to lose your capacity to attract other investors because of the bad experience of a particular investor. So mediation has increasingly, in recent times, become a risk management tool as far as investor-state relationships is concerned. So quickly on UNCITRAL rules, we have the appointment of mediators under your Article 3, and the mediator is appointed by agreement of the parties. It's confidential, that's Article 6. And the settlement agreement essentially terminates the mediation procedure. This is recognized under Article 9, and it should be in writing. So I'll brush on the gold standard for enforceability. Remember, I mentioned at the beginning that one of the challenges with dispute resolution under AFTA was going to be the issue of enforceability. That is addressed under the New York Convention of 1958, where you have over 170 state parties who have signed up to this. And what this treaty is essentially saying is that an award that is made in a particular country on a particular country's laws is enforceable under a signatory state under the New York Convention. Then you have the Singapore Convention on Mediation, which is basically the gold standard, essentially, of mediation, so to speak. And why it matters is that, unlike the positions pre-Singapore Convention, where people felt, well, mediation is an agreement, and so people can remain on it whenever they want to, what the convention has now done is to create a framework for enforceability for cross-border mediation settlement agreements. And so this has increased confidence in the use of mediation for complex investor-state disputes. And of course, it's cost-effective for SMEs. So in a nutshell, what does this bring us to? It brings us to a situation where, in order to maximize the value on the value chain of dispute resolution, you have the multi-tiered dispute resolution system, where you start by negotiation, you move into mediation, and you end up in arbitration. Now, it's important to note that under the African Continental Free Trade Area Agreement, parties can make use of the dispute resolution mechanisms under the RECs, that's the Regional Economic Councils. So your COMESA, the one for Eastern Africa, ECOWAS, the one for Western Africa. However, one of the unique selling points for UNCITRAL is its global recognition. So if a country in the ECOWAS area is relating with, if an investor in the ECOWAS area is relating with someone in the COMESA East Africa area, you can still make use of UNCITRAL. Now, Africa does have institutional success stories, and it is on the basis of this that UNCITRAL can and should be built. So we have the Lagos Regional Center for International Commercial Arbitration, the Nairobi Center for International Arbitration, Kigali International Arbitration Center, the Arbitration Foundation of Southern Africa, and the Cairo Regional Center for International Commercial Arbitration. This is just to mention a few, there are many more. And then, of course, we had Dr. Gaston, who is the main voice on the OHADA system, and it's really an honor to have to speak on the same panel with him. So the OHADA system is a very unique system that shows us that indeed we can have harmonization without uniformity and still get the results that we're looking for. So OHADA has a uniform legal framework. It has regional enforcement and predictability. And it's the strongest example of legal harmonization in Africa. And it has important lessons for AFTA. Then we have the digital dispute resolution mechanism, where you have online mediation, virtual hearings, and artificial intelligence support, especially for the to summarize many documents that may be necessary in a particular dispute. So what are my key recommendations? Number one is the adoption of UNCITRAL's best practices which is one of the things that many countries who have also used the UNCITRAL model law to do have done. Then encourage mediation first approaches or negotiation first approaches, not directly to arbitration because of the cost implication. Then strengthen arbitral frameworks in terms of enforceability, develop SME friendly procedures. So each country can choose to develop an SME friendly procedure under the UNCITRAL rules that is applicable within its own country. Then promote digital dispute resolution and build institutional capacity. So what's the future of African trade justice, like to call it? Number one is harmonization without uniformity. We do not have to have uniform rules. We just have to harmonize them. And UNCITRAL gives us a great platform to be able to do that. Then African ownership. In other words, this is African jurisprudence for African disputes. We can have our own global standards that works best for us in our own peculiar situations. And then commercial confidence. We need to be confident in our own country's laws. We need to be confident in our own investors' capacities to run the businesses that we need to run to increase prosperity for all, as the African Union will say, under our Agenda 2063. So in conclusion, effective trade requires effective dispute resolution, and that includes party autonomy. Parties must be able to decide how they want to resolve their disputes. You have to have neutrality, and which is why the mandatory disclosure is very important. Efficiency, that works when you look at the expedited rules, you realize that UNCITRAL also has the platform for that as well. Accessibility, the rules are not fixed. It is not like an institutional rule, neither is it a rule under a law of a country. It is flexible, and enforceability is recognized under the New York Convention or the Singapore Convention. Thank you very much for listening.
Okay, thank you so much for that insightful presentation. Thank you so much. Now, let me invite the other panel members. Now, I think with this presentation, that set the tone for the discussion. So let me invite an input from Judith, and I'll come to Amaka. Judith, please go ahead.
Thank you very much, and I must say I'm truly delighted to hear how UNCITRAL instruments can be used in practice. Maybe regarding the last point that has been made, harmonization or unification, this is always the balance we need to take. It's difficult to really draft uniform instruments for a continent as big as Africa, or even beyond, if you aim to draft for the world as UNCITRAL does. But still, I would say that there are some issues that should probably be unified, and this is when it comes to, and I understood Foluke in that sense as well, when it comes to issues like enforcement. It has nothing to do with ideology. It has nothing to do with, it's really something technical. So if for enforcement, I would very much advocate for taking over the New York Convention and the Singapore Convention, because this is the only way to achieve uniformity in that way. And this is really an area where you need to have, where you can make sure that dispute resolution is effective. This is what we observed, and that's why we engaged in drafting the Singapore Convention, that without enforceability of an outcome of a dispute resolution mechanism, that dispute resolution tool cannot really be successful. And hence, it's so important to have rules on enforceability, and I would say uniform rules on enforceability.
Okay, thank you. So thank you, Judith, for that perspective. So moving on, I want to come to Madam Elom, and with what Judith said. Judith mentioned that the unification or the uniform harmonization, and when it comes to the use of the UNCITRAL model law, she is looking at it from countries using the New York Convention and also the Singapore Convention when it comes to the enforcement. So I want to ask Maka, do you think that there should be more education on countries to adopt the Singapore Convention, or after needs to come up with a working group that will also draft sort of rules regarding mediation and arbitration for non-state actors trading under the AFTA, so that for the purpose of enforceability? What are your thoughts?
Thank you very much. So I'll still echo the same. Thank you so much for looking. That was a wonderful presentation. And I'll still echo the fact that
thank you,
we are not going to copy. There's nothing like copying verbatim and trying to create. Like I said earlier in my presentation, we are not reinventing the wheel. So the encouragement is, so far, all the member states of AFCFTA are New York Convention members. For the Singapore Convention, we have like 12 states, but it's still growing. So I think the best thing is to encourage the member states to ratify, domesticate the Singapore Convention on Mediation. That will actually cut through a lot of things. It has already been negotiated. So we do not have to go the route again of bringing the 54 member states and we're negotiating what's already existing. So it's for us to ratify it and try to adapt what we have in UNCITRAL for Africa's SME heavy trade. Like Foluke earlier said, state to state, we don't know how heavy it is. We know it's basically B2B. SMEs are the ones going across member states' trade lines. So it's to actually adapt it. It mustn't be verbatim, but we should also be careful. Don't recreate the wheel. We have what is existing. Encourage member states. We're already members of New York Convention. Singapore Convention has done a lot. So as much as possible, the state should ratify it. And then it really help to make AFCFTA dispute settlement between non-state actors much easier. Thank you.
Okay, thank you so much. The same question, Foluke, I want to hear your thoughts.
So if you don't mind, can you kindly repeat it? Because I think my network went off for a second.
Okay. So starting from where Mrs. Gold stopped, she was talking about not reinventing the wheel and also the need for countries to be encouraged to adopt the Singapore Convention. And she's sure majority of the states under the AFTA have adopted the New York Convention. So there's the need for us to encourage the states that have not adopted the Singapore Convention to do so. This will create an enabling environment. So the question was, should AFTA draft a new rule or convention for non-state actors to be able to have an enabling platform, or we should encourage states to adopt the New York Convention and also the Singapore Convention, so that it will make it more easier for non-state actors to have a platform to resolve their issue, and also have the back of their mind that their issues that they resolve using those mechanisms will be enforced for the purpose of enforceability. So that is the question.
Yeah. Okay, so should AFTA come up with its own rules, or should we just adopt Singapore Convention?
Encourage countries.
Yes, considering how long it has taken for AFTA to come on stream, and considering the dynamics that goes with discussions when it comes to agreements that states have to sign up to, I think it's just best for states to deal with things that they can deal with internally by adopting the Singapore Convention. Because we have seen, especially with the discussions on the investment protocol for AFTA, we have seen that document go back and forth. When AFTA itself was fully agreed to at the Kigali meeting, it wasn't signed. In 2021, when AFTA fully came up on stream on the 1st of January 2021, the investment protocol wasn't signed. Right now, we're not even sure if if there's been a conclusion on the investment protocol, because that was supposed to create the platform upon which non-state actor dispute resolution mechanisms was going to be addressed. So pending the time after comes around in this, deciding on how to go about this, I think it is best for countries to focus on what they can handle internally, and which is adoption of the Singapore Convention, particularly because mediation helps to preserve relationships a lot better than arbitration would. It's also relatively cheaper, and it also helps to ensure that those relationships that Africa really needs to continue to grow, for prosperity to grow as well, continue to be preserved going forward. So I think it's just best to stick to what is simple. The low-hanging fruit is adopt the Singapore Convention. Let it be easier for SMEs and business leaders to be able to make use of that platform. And then when after eventually concludes on the investment protocol, especially the dispute resolution aspect of it, then we can look at what provisions it provides for the investor or the African non-state actor. But until then, let's work with what is a low-hanging fruit for us. That was my thoughts on that.
Yes, great. Thank you so much. Since the two of you and Amaka are coming from Nigeria, have adopted the Singapore Convention, which is a good start. Ghana signed in 2020, but we are still not ratified. It is still in the books. So, what do we do at this point? What do we do to encourage states to ratify the Singapore Convention? And this will go to you, Foluke. What do we do? What do we need to do? Because the Singapore Convention is there and allowing states to be able to enforce a state. Even there are exemptions that the state can say that we agree to this, we don't want to agree to this, but still, African states, only 12 out of the 54 have adopted it. What should we do?
Interestingly, this was part of my article to the International Bar Association there was a special focus on Africa, and this was exactly my argument. Keep it simple. We don't want continent-wide discussions that can delay business activities. So why not have African states just adopt the Singapore Convention? So to be honest with you, there isn't a straightforward answer to that, because even under the Vienna Convention in international law, you cannot force a state to do what you wish they could do. And the present geopolitical dynamics in the world right now, without going into details, is an example of that. However, there are provisions under the regional economic communities that allow for states to be able to make use of what we call good offices, just like the good offices under the WTO treaty. And what that essentially is focused on is on negotiations. So pending the time states do sign up to the Singapore Convention, we can have states just make use of, or we can have businesses just make use of what is already provided for, which is the negotiations under the regional economic communities. So if it's a West African country or West African investor, you can look at the ECOWAS provisions. If it is a South African investor, you can look at SADC, the South African regional bloc, the ones for North Africa as well. Because at the end of the day, businesses are not going to wait for the legal framework to meet up with their issues. And so you make use of what is available. So yes, we'll encourage countries to sign up, even on the implementation committees of AFTA in different African countries. That could be tabled before them as a low-hanging fruit on resolving disputes via mediation and more cost-effectively via the expedited arbitration rule of UNCITRAL. But pending the time those rules are put on ground and are put together, there are already existing rules under the regs that can be used within the regions that can help reduce the cost exposure of dispute resolution. That would be my take on it.
Thank you so much. Let me move on to yes, thank you. Let me move on to Amaka. I want to find out from you, what should be the role of AFTA in making sure that they create enabling platforms for non-state actors learning from UNCITRAL?
Okay. For UNCITRAL, for AFCTA, I think we are aware that it's up for review, or that it's due for review at this point. So I would think that it's also an opportunity to clearly make reference to UNCITRAL rules. But remember, we are talking about 54 states with different ideologies. And like therefore Lucas said, you cannot basically force anyone, you cannot force a country to ratify what it ought to have ratified. You cannot do that. So basically, we would hope that in the review of the ACFTA would find a way to make a reference to UNCITRAL, but there are options, like has been mentioned, there are options that the member states can rely on, while we are hoping that everybody gets to see the light the way they saw the light and ratify the New York Convention. And we hope they will understand that and do that for Singapore Convention. For us as a country, we've already done that. It's working well for us. It cuts across a lot of bureaucracy that SMEs have been facing so far in practice. So for AFCFTA, for us, the country, is for us to put that on the table, encourage that, but you cannot actually force anyone. And I believe out of the 12 African states that have already ratified the Singapore Convention, I'm sure from experience we'll be able to encourage member states that in the review of the AFCFTA, such provision can also be made if possible. But I don't think it's a hindrance as of now. Whether the states ratify it or not, we encourage it to be done so that we align and it's easy for AFCFTA to actually be implemented. But it's a difficult, it's issue about diplomacy. And we hope that the member states will understand its importance of having a clear convention that will guide our mediation relationship. Thank you.
Okay, great. Now we come to Judith. Yes, advise us on what do you think the steps that we should be taking.
That's a very good question. I think the Singapore Convention is in fact not such a difficult convention to implement, because the only thing you have to take care of is that courts are ready to accept settlement agreements resulting from mediation. So there is no need to create a body. There is no big costs involved with adopting the Singapore Convention. What you could see is that the uptake to the Singapore Convention was much better than the uptake of the New York Convention when that was finalized in 1958. So we have and we had the COVID times where there had been no uptake of any treaties because we all were standing still, so to say. But you could see that the uptake is much higher because there is the need for a simple dispute resolution tool. What we have, if you are advising or if you are discussing with government officials, we have on our website an accession kit. We are always ready to help government officials if they want to take the question up within their government. So we are happy to provide advice and to help out. And I think one additional point is that promoting the Singapore Convention and promoting mediation is a key issue, and that's why I put in the chat a link to the Singapore Convention Week 2027, where we have also a conference organized together with UNCITRAL. The timing might not be ideal for many of you because it will it will happen at in the time zone of Singapore, of course, but you might wish that there are events throughout the week, and you might wish to jump in maybe for those events that take place early in the morning or so. That is certainly something you could do, and what you could do as a private party. I also would like to remind those that the convention, of course, needs to be taken up by the states and ratified by the states, the model law as well, but the other texts are available as of now for everyone. There's no need for the state to take it up. The UNCITRAL rules, be it arbitration or mediation, and all the explanatory texts. So this is certainly something where all of us could help promote mediation, which maybe creates sufficient pressure to states to take up the instrument from which we hope that it would enable mediation on the long run.
Thank you so much. Okay, now let me open the floor to, we have some few minutes to go. So let's open the floor for individuals who want to have questions. Please, if you have a question, do raise your hand or put them in the chat. We'll read it, or you raise your hand and talk. So please, the floor is open.
Hello. Hello.
Hi.
Hello, yes. May we know your name, your country, then you can go ahead, please. Your name, your country, and go ahead with your question.
Hello.
Hello.
Are you getting me? Yes, thank you. I'm Dichik Mary Amukum, an MCF. I'm a Cameroonian and working with the Supreme Court of Cameroon.
Okay, great.
I'm very sorry I stepped in late, but from the few enriching presentation I've gotten, I think I can say I've been updated on so many things. Now, my question goes to Judith about the Singapore Convention. I think many countries are signatories to the US Convention of 1958. And talking about the Singapore Convention, I would like to know what is the scope of the Singapore Convention compared to the USA Convention, where many countries are signatories. What is the scope? Is it's just coming to cover Africa? Is it a universal scope? What is the extent? And why go in for Singapore after we have signed for the US Convention? I want to get the glaring advantage so that we can be able to motivate our states to get involved. And as I'm speaking, I don't think I'm informed that Cameroon is a signatory. And if she isn't, those of us who are practicing arbitrators can be able to see how we can meet the authorities concerned and encourage them to go in for Singapore Convention. What is the advantage of the Singapore Convention over the US Convention? I really hope that my question is clear. But if it's not clear, I will come back to it. Thank you, Judith. And I think the president will have to come and say something too. Thank you.
Okay, thank you so much for your question. I think, Judith, please, you can go ahead and answer.
Yes, thank you very much for that question. That's indeed a very good question. Maybe to start from with your last question, because there were several questions involved, Cameroon did not sign up to the Singapore Convention. The big difference is that between the New York Convention and the Singapore Convention is that these are two different instruments that both are on enforcement, but the New York Convention is on the enforcement of arbitral awards, and the Singapore Convention is on the enforcement of settlement agreements resulting from mediation. The New York Convention is certainly something you could call a quasi-universal treaty because it has 172 ratifications. So, or accession, so 172 parties to the New York Convention. The Singapore Convention for the time being has 22, and in addition has 48 signatories. And 22, you could still not say it's a universal convention, but what one could say that there has been an uptake by all regional groups, and we have a number of big players that are in the process of considering the ratification, like China, India, all of those who signed up to the convention. The biggest argument is probably that it would allow states to have, in addition, to offer their businesses and to offer their investment in addition, their investors, in additional dispute resolution tool. You have mediation already in many laws, but when it comes to cross-border enforceability, there was a gap. And the hope was that the Singapore Convention would do for mediation what the New York Convention did for arbitration. And this is probably the key point why states wanted to draft such an instrument at the beginning. We heard we don't need to reinvent the wheel. No, the wheel has been invented by the states. So the wheel has been invented by everyone. The wheel has been invented by Cameroon. I mean, co-invented by Cameroon, because everyone was in the room. So it's really just the uptake of something that the states did invent themselves. So it's not reinventing the wheel, it's profiting from the work they did themselves. That's how I would phrase it. And this is probably what needs to be done now.
Okay, thank you. So with your question, the understanding is that the New York Convention is particularly for arbitration, and
Yes.
the Singapore Convention is for mediation. So what the New York Convention did for arbitration, for it to be accepted and enforced worldwide, it is the same aspiration that the Singapore Convention on Mediation is also seeking to achieve, so that people who are going into commercial mediation can also have a platform to enforce their outcome. So that is the focus of the Singapore Convention on Mediation, right?
Okay.
I hope the questioner is okay and satisfied with the answer.
Thank you. I'm satisfied. But if there's an opportunity of asking a second question, if not, it's carried forward to some other session. Thank you.
Please do. Please do. Maybe the next session will be next year.
Okay.
We do a session
okay,
when
so do I ask my question?
Yes,
do I
please
ask
go ahead.
another question?
Yes,
thank you. Now, I want to know something about the DSB of the WTO. Yes.
Okay.
Are
you saying WTO or after?
Well, in as much as I know that there is a dysfunctionality with WTO DSB, even at the level of after, well, I don't know whether that of after is functional, because it's true that at the level of after, they're still trying to pick up. So understanding that the main WTO DSB is dysfunctional, is there a possibility for us to be able to cause after DSB to function with independent of that of WTO? That is the first part of my question. The second part of my question, has to do with the context in which we find ourselves as African. Is it not possible that we can be able to have our own convention independent of Singapore, independent of the US convention? My question is one question divided by two independent parts. Sorry for the mixture. I think it goes through.
Okay, all right.
Am I understood, sir?
Yes, you understood. So with this discussion is not focusing on WTO, but somebody will come in and answer some of them with whether it is function or not. WTO deals with state to state, the same way as AFTA is also dealing with state to state. But what is happening in the WTO is that it is the appellate body, the normal dispute bodies are working properly, but it's the appellate body where some of the countries are having issues with the appointment of the appellate judges. So it is not fine, it is functioning. But when you are dissatisfied with the ruling and you want to go up, that is where the challenges are happening. System
Okay.
is a little bit different from what the WTO. We have, you start from the good of it. You can do mediation, conciliation, or arbitration. Then before you can request for the setting up of the panel, then through that, if you want to go up, there's also an appellate body for that. Then with your question on whether or not we should create our own convention. So I will leave this one. I will leave Foluke to comment on the first one and the second one. I've seen her hand up, so please go ahead.
Okay, I think that, and thank you very much, Madam Mary, for the question with respect to an Africa-centric convention, essentially. I think at the end of the day, it's not so much as having something generated from Africa for it to be useful to Africa. And what do I mean? We have an instrumentality in the rules of UNCITRAL that we can use to ease the burden of the complexity of waiting for the states to agree to a convention. That's on the one hand. On the other hand, the states themselves can choose to adopt the Singapore Convention for its own use. The Singapore Convention is helpful for state-to-state or cross-border transactions. And which is why in one of my slides, I talked about African trade justice. The fact that these conventions, the Singapore Convention and the New York Convention, are not African creations, for the lack of a better word, does not mean it cannot result into African results. And so we would certainly have, based on the use over time, cases that would come out of the enforcement of awards under the New York Convention or settlement agreements enforced under the Singapore Convention. So in doing that, we are creating our own African jurisprudence using the instrumentality of the Singapore Convention and the New York Conventions. So it's not as if we need to again reinvent the wheel, because a lot of years go into negotiating these treaties. What is best for us as Africans is to take what is already available and to make it our own. So for the Singapore Convention, start by enforcing agreements, settlement agreements within the African continent, and use that to enforce our own style of settlement agreements. Already, Africans have a culture of collaboration, and that can be built upon in the mediation settlement agreement mechanisms that we're working with. So traditionally, you will have the elders who would come and ask people to settle. So especially with respect to our land borders within communities, you will have elders call the parties involved to talk to them about how to resolve the disputes amicably so that the relationships within the communities are not adversely affected because there are disputes over land boundaries. So it is that same culture of collaboration and communalism that we are trying to bring into the international investor-state dispute space by saying, yes, we have these conventions, they are not created by Africans, but they are tools that can be used by African states, used by African investors to push forward the African agenda of prosperity for all, Agenda 2063. That is my humble suggestion on that. Thank you.
Okay, thank you so much. They have seen some hands up. We have 9 minutes to be out of here. Benjamin, are you open for us to extend the time a little bit? What's your take?
No, of course, it's fine. The discussion is lively and very interesting for us, so we are of course glad to stay. I'm listening. I'm listening because I want to add the content to my concluding brief remarks.
Okay, great. Okay, thank you. Right. So now then we come to Judith. Your hand is up. You wanted to share something on what is happening. Yeah.
No, I just wanted to share that I couldn't agree more with Foluke, because what is important is, and that's the idea of UNCITRAL, to negotiate in an inclusive manner, and everyone is invited. Where I see that in the future, I would very much urge every African state to send proper delegations to our meetings, especially Working Group 3. We are now discussing the appeals mechanism, we are discussing the first instance mechanism, we are discussing the provisions, including cross-cutting issues, which includes, and this is of main interest for African states, rules on damages. So, and we do include we do discuss this mechanism, how to change the old generation treaties. All of this is really something where Africa should be participating. There is no point in having everyone drafting a convention on enforcement, on arbitration or mediation in every continent. That makes no sense, because the businesses are operating not necessarily within one continent. But the idea of UNCITRAL is really to combine forces and to make the best possible text for everyone, which means you all should participate so that we get the best possible text out of it. So I would really urge all states and all of the stakeholders who are invited to actively participate, so that our future instruments become even better, and that you have less difficulties in joining those instruments, because these are somehow your own instruments. So this is just the addition I wanted to make. Otherwise, I would sign everything you just said, Foluke.
Thank you. Okay, so Ms. Amaka, do you want to share anything on that? Please, we have also launched a poll on your screen. You can take a few minutes and also answer them for us. We want to have a feedback from you. Yes, Madam Amaka, are you there? I hope you are there.
Yes, yes, I'm there. I'm there, Isaac. Thank you for giving me the floor once more. I wish to comment on this issue of Africa coming out with a similar convention like the Singapore Convention. I would just like to say that some African countries are already moving towards that and have actually done something. Because when you look at the OHADA region, the Uniform Act on Mediation, there is actually a part there which deals with the enforcement of settlement agreements. And when you look at these particular sections and the sections in the Uniform Act which deals with arbitration, you will realize that a settlement agreement in the OHADA region can equally be homologated in the same way that an award will be homologated. That's before the court, or exactly before the court. So I think that Africa is doing something, and it is now left for other African countries, if they could join in to the OHADA region. That will be a very strong instrument as far as mediation is concerned in Africa, because they have actually done a lot. When you look at the procedure, I think that the Uniform Act was adopted in 2017, even before the Singapore Convention in 2018. So the Singapore Convention came after the Uniform Act on Mediation. And I believe, hopefully, Cameroon will sign the Singapore Convention. But now it's left for the parties to choose which of the conventions they have to adopt. If they adopt the Uniform Act on Mediation, good and fine. If they adopt the Singapore Convention, good and fine. But to say that Africa has not done something with regards to settlement agreements, I think that would be an overstatement, because the OHADA community has actually moved a step forward by seeing into it that settlement agreements arrived at within this community are effectively implemented. So that's just the element I wanted to bring in. So Africa, it's actually doing something. It's not like we've just folded their arms and they're waiting to import from what the international community as a whole is doing. If they were to go into the Singapore Convention now, I think they would just be picking out maybe some elements to improve on what Africa already has, which is the Uniform Act on Mediation. Thank you so much.
Great, thank you so much. So the OHADA Act is a good, yes, I'll come to you, Judith. The OHADA Act is good. We are not saying the OHADA Act is not good. What we are saying is that we are not saying that Africans have not done something. What we are saying that we need something that is universal, because for now the OHADA is for 17 African countries. So what about those outside the 17 African countries? The enforceability and for easy way for non-state actors to be able to enforce the outcomes. That's what we are looking at. Yes, Judith, you wanted to add something?
No, I wanted to add that when we were negotiating the Singapore Convention, we very much profited from these experiences. So we took on board the difficulties that were faced by OHADA and that were raised in our meetings to try to decide how to overcome some of the difficulties. So we profit extremely from, and this is why it's so important for all of the African states to properly participate, because this allows us to make the text better. So there is not the international community on the one hand and Africa on the other hand, but the UNCITRAL is Africa.
All right, great. Ngozi, please go ahead with your question. And we keep reminding that please do well to do the evaluation for us. Do the evaluation for us. We have about 17 people who have responded. So the rest, please do respond for us. We had over 66 people online, but now we have about 51. So do well to evaluate it for us so that we'll know whether we achieved the outcome or not and whether this was worthwhile. Right. Thank you. Ngozi, please go ahead.
It's worth listening to all of you who have spoken, the speakers. Said I've learned a whole lot today. I'm a mediator, not an arbitrator, but my spirit is now tilted towards going into arbitration as well. So I might more like an addition and also a question. Now we are discussing about how to bring about predictability with respect to mediation. And because the world is now a global village, that's why we are talking about Singapore Convention. But at the meantime, where two contracting parties, probably one is from a country that has either the OHADA, let me even add that, or the Singapore Convention, and the other do not have any, neither of country has not ratified any of these conventions. Can the party now, through their contracts, decide that for the investor, for the party that the country has ratified either of these conventions? Okay, OHADA is not a convention. For instance, the Singapore Convention. Can both parties now agree that it will now be that of the other contracting party where the Singapore Convention has been ratified, that Singapore Convention should be the deciding, or the parties will now, with issues that will evolve from the contract, that it is that that will now decide on the issue. I hope my question is clear.
I think I didn't get your question well.
My question is, either of these parties, probably one is from a country that the convention has been ratified. Can they, through their own contracts, the contracts that both of them now enter, just like you would decide to have an arbitration or mediation clause in your contract, can they now decide, okay, in the event of issues arising from this particular contract, that the country of XYX, where the convention has been ratified, will take preeminence? That's my question. The other was an analysis.
Yes, so if I understand what you mean is that maybe, for instance, Ghana and a Nigerian is entering into a contract and they are choosing mediation. Nigeria has selected or has ratified the mediation convention, but Ghana has not ratified it.
Yes,
so
yes.
you are saying that the Nigeria one should supersede, or they should choose Nigeria as the seat or the venue for the process. Is that what you are saying?
Yes, that's what I'm saying. So I can see Madam Judith. Okay.
But one thing is that if it comes to the reciprocity, if you have to enforce the law in the outcome in Ghana or Nigeria, that is where the difficulty will come. So it depends on where the injured party is from.
No. Sorry. The Singapore Convention is very special.
Let me give the platform to you, Judith. Come in.
Sorry. The Singapore Convention is special. There's no mediation seat and there's no reciprocity. So if you are from two states that have not been joining the Singapore Convention, you can still enforce in a state that has ratified the Singapore Convention.
Yes, so my issue is
states that have not.
My issue now is, for instance, the person you want to enforce the outcome against is in Ghana, where Ghana has not ratified the Singapore Convention. So how do you do that?
No, you cannot enforce in the state that has not exceeded.
Yes.
But if you have someone from a state that has not joined the Singapore Convention and another party from a state that has not joined the Singapore Convention, you can still enforce, either party can still enforce in Singapore, because Singapore is, or in Nigeria, wherever. So this is the big difference to arbitration. There's no seat and there is no reciprocity. So for states that are parties who are not from countries that joined the Singapore Convention can still be under the Singapore enforcement regime. If there is property, for instance, in the Fijis or wherever, in Nigeria or in Singapore, in a state that joined the Singapore Convention. So this is very special, and this is why parties should also pay attention to the Singapore Convention.
Sorry, I interjected, because this actually answered the question they have. What happens where one contracting party is from a country that has ratified the Singapore Convention, and the other contracting party is from a country? He gave a classical example, Nigeria and Ghana. So that is where the question is now. Ghana is yet to ratify. Now, where would the seat be? That is my question.
There is no seat. So you could enforce in Nigeria, but not in Ghana, because Nigeria did ratify. But if you have a state, if you have a party from Ghana and you have a party from Austria didn't ratify. The settlement agreement could still be enforced in Singapore or in Nigeria.
Yes, but this is where the difficulty comes in. You can enforce it in Nigeria or in Singapore, when maybe the other party that you are enforcing against does not have any property or anything in Nigeria or Singapore that you can get. That is where the difficulty. I think that's where she wants to clarify. Because if that is the case, then it means that you cannot enforce it against the person. Because if you enforce it there is nothing you are going to get from that particular country. I hope that is clear.
You need assets to be able to enforce.
Yes.
There we all agree.
Yes. Okay. Great. Now,
can I add?
Thank you, but I want to hear from Foluke, who is a Nigerian.
Foluke, please go ahead.
Okay. I think first and foremost, we need to distinguish between using the rules and using is the enforceability aspect of the rules. So yes, you can make use of the Singapore Convention, but the part that has to do with enforceability is very strictly based on the countries that have not only ceded to the convention but also have ratified it. So, in other words, if based on those countries' laws, the way that international law operates in that country is for it to be passed by the parliament or the legislature of that country, it is until that step has been taken before you can make use of the convention within that country. Now, just like Madam Judith had mentioned, with the Singapore Convention, you don't have the issues of seat or reciprocity. What that means is that you can then enforce in other countries outside the parties that are in that agreement. In other words, you can look for assets in countries where the Singapore Convention has been ratified. However, it is very possible for the case to be between two African countries and where the assets are located is not the country where the Singapore Convention is enforced. Mediation settlements, the mediation system itself in that country is what will then be looked into. In Nigeria, for instance, if a matter doesn't fall within what the Singapore Convention covers, then you enforce the mediation as either a settlement agreement in terms of a contract, so specific performance, or you enforce it as a consent award, where you take the settlement agreement and you get an arbitral tribunal that would enforce it or would sign off on it as a consent award, or you get it as a consent judgment. So you go to court and have it registered under an ADR judge that would then make that settlement agreement a judgment of the High Court that can then be enforced as if it's a judgment of the country. So there are other regimes that you can make use of in the situation where the Singapore Convention is not applicable in that particular circumstance. So it is up to the legal advice that you get in the particular country that you are seeking enforcement to first and foremost look at the low-hanging fruit. Are they signatories to the Singapore Convention? If they are, and have they ratified? If they have not, then you move on to the next stage. What are the legal principles that govern enforcement of contractual relations? Every country has laws with respect to the enforcement of contractual relationships. And so if the convention, if you don't have a convention, you're not able to resolve the issue by way of a convention or a treaty, you can resolve the issue by way of applicable law within that country. And the beauty of mediation settlement agreements is that it is not it's not a special species like awards, but it is still seen as a contractual arrangement such that it can be enforced in that light as well. And sometimes it might even be cheaper to enforce it in that light as well.
Okay. With even your last, when you see, it depends on the country where it is seen as a contractual agreement between the parties. They are based on maybe their text of their law. Some of them make it more like an arbitration award. Even when you look at the Ghana, the current acts, the AD Act 2010, it likens mediation outcome to an arbitral award, so that it is
because
easy
of enforceability.
Yes, that is
exactly
how it makes it. Yeah. Right. So I think Ms. Amaka hands is up. Please go ahead.
Okay, thank you very much. Yeah, everybody has made the right answers, given the right answers. And I believe that the Madam Rosalind is well satisfied now, but she should also remember the bottom line is that what did the parties agree to be guided by? They must have agreed to be guided by particular rules in settling the disputes. So by the time they have that agreement in their contract, they would, of course, have the understanding of how it will be applied or implemented. So there is no contractor, there is no investor that would, on its own, just institute an issue or a matter under what has not been agreed. There must be consent. That's just the job. There must be consent between the parties on what they will use to settle the dispute. and what format? Thank you.
Okay, thank you so much. I think Benjamin has shared something in the post, and we can look at it as well. Right. So now I want to bring the panel discussion to a close. So I'll now take last words from Judith, come to Amaka, and I'll go to Foluke. Then we bring the panel discussion to an end. So Judith, I want to hear your last key takeaways.
Looking forward to continuing our discussions in the future. It was a real pleasure. So I do hope that at latest when Cameroon is exceeding or ratifying the convention that we have the next webinar.
Great, great, great. Okay, let me go to Ms. Amaka.
It has been a wonderful time, and I believe a lot of us have learned how important it is to be on the same page. And though Judith will say she doesn't prefer the word reinventing the wheel, but I'll continue to encourage for Africa. Yes, we are doing a lot, but as developing countries, there's so much out there we could align with. Instead of replicating the hours that have been spent in negotiating as members to produce a particular convention or treaty, and then we'll come back to Africa is still part of the world. So we encourage alignment of existing international treaties to make our job quicker and faster. And we hope that this will still hold next year. It has been a pleasure. See you, my dear Judith. Thank you so much.
Thank you too for joining us out of your busy schedule. We are grateful to have you. Let me move on to Foluke.
Okay, so thank you very much for having me. What I would just say is Africa is ready for business. And for us to be ready for business, we need to have dispute resolution mechanisms that are predictable and are certain and will ensure investor confidence. And for investor confidence, we need to walk the talk. And so if we cannot find a solution in A, we can find it in B, but we must find a solution to ensure that businesses continue to work without any hindrance to their capacity to expand. Thank you very much for having me.
Thank you so much. It's been a pleasure moderating your session, and I'm delighted that you all join us to share your insightful ideas that Africa can use to develop itself and to make sure that we learn from the people who have taken the lead, such as UNCITRAL. UNCITRAL is 60 years. So if it is an African mandate, most of us will be going on retirement. So going on retirement, there is a lot of wisdom to share. And it is important to always learn from them, right? So we'll now take our closing remarks from Benjamin. Thank you.
Thank you, Isaac, and I will be brief because I think a lot has been said today, and I don't want to add to that. I want to really thank you, Isaac, and thank the IFCC DR for organizing this great session. I think it was very, very excellent, including the survey at the end and the recording as well, which I hope will be shared because I think it's very important in terms of assessing our activities and also ensuring that they are being used even after they're concluded. Lots of things have been said about how UNCITRAL text may come into the picture when IFCFTA is being implemented, and that would benefit SMEs, but also bigger companies in Africa. I think the case has been made that Singapore Convention would be a low-hanging fruit, as was said, but also that explanatory guidance available on UNCITRAL website does not need to be enacted or ratified by states. So there's much also here to benefit from or to learn from for practitioners and academics. I think also we all agreed that many African countries have already been moving toward the implementation of the IFCFTA, I would say individually or also in groups such as the OHADA, and I think this is something that we need to stress and to acknowledge and to also encourage. But of course, there is always a tension that has been illustrated in the discussions between this willingness to grow as a continent, and then maybe the risk that there is to reopen some issues that were discussed by African states themselves in UNCITRAL. And so there is, I think, something here for all of us to bear in mind. And I really want to thank the 65 people I've seen joining the session today. It's great. Thanks a lot. And of course, we look forward to further activities with you, Isaac, and with the Institute. Thanks a lot, and have a nice day. Bye-bye.
Okay, thank you. And from us at AFCOT, we want to say a big thank you to UNCITRAL for trusting us to host this event. When Benjamin first sent me the email, he said, okay, yes, we can do this. Can you propose a topic? And I proposed the topic, and he said, yes, it's a good topic for us to discuss. And I must say, thank you so much. And all the long emails trying to find speakers and all that. Thank you so much for the good work. And thank you to the speakers for accepting to join us. We are immensely grateful to all of you. And to the participants, we are starting the African ADR conference on Wednesday, and we hope to see you online as well. Register and join us. Let's talk more. It's through talking, through discussions, that we can find more better solutions for African and the way that we can resolve our conflict effectively. On that note, from us at AFCOT, we say a big thank you to all of you. And this brings us to the end of the event. And we'll share with all of you the recordings and some of the pictures as well. So thank you all, and thank you. Bye-bye for
Bye-bye.
Thank you so much. Thank you so much, President.
Bye. Next time my
Thank
video
you.
would work, I
Bye-bye.
believe.
Bye.
Bye.
Thank you.
Oh, okay, somebody just raised his hand. Judy, you wanted to talk now? Okay. Now let me stop.